And over all the members. So, but is auto dating monthly, we have press matters at 2 months ago. Auto dating matters are auto dated, all press matters. Yes, sir. We are targeting the cases up to 2017. If we have the list, we have the list. 2017 or go target month. Up to 2017, we want to target cases up to 2000. Sorry, you're opposing, Mr. Mr. is opposing. So please argue when the matter is taken up. Sir, case Kardaga, the case is called out to make a mention. Let us see. Number? Learned counsel for the petitioner. Petitioner respondent. Petitioner signed. Yavattu. Yavan date. Seventh. Wait. Learned counsel for the petition seeks time as the last chance to respond. 7th. Yes, Mr. Request to learn counsel for the petition respond. We want to grant a release extend to the next. From Monday, it's all the. No, madam. Sorry. 2016, please don't expect an adjournment in 2016. The request to learn counsel for the petition respond as a last chance. Tomorrow is extend to the next. To learn counsel for the petition list tomorrow as a last chance. Mr. B.S. Prashant submits a memo. The petition has become inferred. Memo is placed on record and the petition is dismissed as inferred. Yes, sir.
Your Lordship, if I may be permitted to submit.
Why 26? Huh?
Your Lordship, if I may be permitted to submit.
Filed a memo to the petition. Memo is placed on record and the petition is dismissed as referred. Yes, sir.
Your Lordship.
Please adjourn.
Your Lordship, list number 2, serial number 1, Your Lordship. Sorry, I'm unable to hear.
I understand the court. I've been telling everybody on lawyers on the VC, you should wait for your turn.
Sorry, Your Lordship.
Please adjourn. Yes.
Our Lordship, list number 2, serial number 1. Your Lordship, we recently filed our NOC Wakalat.
List number 2, serial number 1.
Yes, your lordship. Well, for the petitioners, we have informed the other side, your lordship.
Any objection for adjournment? They not paid the interim maintenance as ordered.
Lordship, because we recently filed a NOC, so I'm unaware, your lordship. So
Not entitled to any indulgence by the court. Pay the maintenance, get an adjournment. If you don't pay maintenance, no adjournment.
lordship, I was unaware of that, your lordship.
We'll decide the case. Yes. Correct. Yes. The request of learned counsel for the petitioner, please intimate the other side, whoever appears. As a request of learned counsel for the petitioner, this comes also as the last term. That is. The learned counsel for the petitioner has filed a memo to withdraw the petition since the trial has already begun before the trial. The memo is placed on record and the petition is dismissed as withdrawn. 1 week time is granted to do the needful, failing which the interim order granted by the court on 28/6/2018 shall stand automatically dissolved. Counsel for the petition next. Counsel for the petition has filed a memo to withdraw the petition. The memo is placed on record and the 14 also same one. Please hand over the memos. Don't go away just like that. And withdraw this petition, file a separate petition if you want.
That's what the court had suggested, and that's how it's supposed to be. Even for that.
The learned counsel for the petition, learned senior counsel representing the respondent number 2 submits that the who, therefore, this petition does not survive for consideration. Hence, the petition is dismissed. However, it is open for the petitioners to challenge the charge sheet in accordance with law. What is this IA 1 of 23? What is IA? What is the IA? Nimmatru kapil one. Namatre told. Dismiss the. I am pleased to dismiss the above criminal petition as the petition has not completed the order dated 5/12/2018 as well as 7/11/2022. Besides, as on this date, no copy of the petition has been served on the respondent number 2. What is this 5/12/2018? 5/12/2018. Have you? What is the other order? 7/11. Is what? There is no conditional order. Yes. Yeah, but however, charge sheet was filed when our further proceedings in crime number. What is the date of filing the charge sheet? 5/12/2018 is the date of the interim order. 27. So 18. Charge sheet is filed. Correct. But we have intimated the order to the police. EP9. When was it filed before the? It was filed before the court. With the delay of 3 months.
Now the bills are not paid. The solution are you don't know why it's all.
One of them, right? To dismiss the criminal petition for non-compliance of the order dated 5/12/2018 and 7/11/2022. To stop. The order, the office has raised an objection that the copy of this application is not served on the counsel for the petitioner as well as its learned HCGP. To stop. The office objection on this application is overruled. Next para, it is seen that the order dated 5/12/2018 and 7/11/2022 was not conditional. To stop. This court had admitted the petition and had granted the interim order stay of all further proceedings in crime number 278 of 2017. Pending trial before the 4th ACMM Bangalore City. To stop. It is now stated at the bar that the prosecution has already filed a charge sheet on 27/11/2018. That is subsequent to the grant of interim order by this court. Next, since the petition is admitted by this court, and since the order dated also is not conditional, question of dismissal of the dismissal of the criminal petition does not arise. So hence IA number 1 of 22 is rejected. Vasudevan. Uyog Herle. Come this side. What is the case about? What is the case about?
Regarding the NTP4P, those facts repeating it. Keep a petitioner for 5/4/42, the entire email communication. That is,
At what stage you filed with the criminal petition? At what stage was this criminal petition filed? There is a tendency to file a criminal petition once a crime is filed. Whenever a complaint is lodged, it is followed by a criminal petition before the High Court. You don't allow the investigating officers to look into this. You want the High Court to look into all this. So if you say that there are many emails which backs your claim to innocence, why don't you place it before the investigating officer? Correct, sir. Let us see the complaint. What is what does the complaint make? Read the complaint at annexure A.
The complainant has to report to her immediate boss, Mr. John Mills. He is the managing director of RCI, EAC and EAE. That the said John Mills has been repeatedly making comments targeted at the complainant, including making comments verbally on which the complainant would often disregard and ignore. The contents of the said communication were not always very cordial and had unpleasant taste and sexual
Innuendos.
That on 12/3/2019, the said accused John Mills, having the knowledge that of the complainant owning some shares, sent an email to the complainant on 12/3/2019 on at 2:03 a.m. in the middle of the night. The said email, the said accused gave the link being also, and thereafter he stated as under. Can I be your
Chauffeur.
Three exclamation marks and putting the smiley sign at the end of the said message clearly shows the accused was making suggestion and was being done verbally. The said message had nothing to do with the official discharge of the obligation by the complainant or by the accused, and which was only aimed to mentally harm and harass the complainant in the middle of the night. That thereafter the accused John Mills immediately wrote a further mail on 12/3/2019 at 7:60 a.m. with the further with following content. Champagne on your tonic.
On you tonight. Tonic color.
The said email was further in extreme poor taste, apart from demeaning, defaming, derogating the complainant and showed him to be demeaning the complainant as an instant gratification. Email is extremely derogative of the complainant as a woman and has huge elements of sexual overload. Because this email on many occasions it like let's write together. I make a good shopper. You can try, which gives a statement of different meaning. That the said accused John Mills has of late step his animosity against the complainant on getting an encouragement. The complainant rejoined her office after almost a month on 15/6/2019 at Bangalore. In the morning, she made a formal complaint against John Mills. To her surprise, her harassment and intimidation on 16/7 at 11:30 a.m. on 17/6/2019.
So what are the emails you want? What are the emails you wanted to read?
You are to
525.
page number 32 more.
Correct, sir?
Page number 32.
Oh,
These are the emails.
ah.
The communications between the two persons who are top level management entities. Here, this is in context with acquisition of the Yatra.com. Yatra.com is the complainant is one of the co-founder of Yatra. $36 billion acquisition. $36 billion. In this regard, the petitioner sent an email saying that congratulating, if you see the subject line, my lord, edicts makes $36 million bid for Yatra.com plans expansion in Indian market. Here this is, my lord, page number 33. Emails go like this. On March 12, 2019 at 2:03 a.m. At that time, he was in Singapore. He says, "Can I be your shopper?" With his fine. Subsequent to that, the complainant response. Same day, 12 March 2019 at with an exclamation mark.
So where does it say, can I be your shopper?
Page number 33 minus. Emails are in page number 33 at after the STDPS. Can I be your shopper? This is what she has put in the complaint, but she has not intentionally put these emails. Subsequently, she says to that email. Again, then it replies, "Champion on you tonight." For that, she replies on 12 March 2019 at 9:47 a.m. Complaint number 32, middle of the page. She says that, "Yes, I just got the news that that board will agree to the offer." These are the communications. Let's stop senior level management. When an offer is made, as a satirical banter, we express these. This is the complaint is majorly against a petitioner in 525. This is accused number 1. Accused number 2 and 3.
What do you mean by let's write together?
There is nothing, my lords. It is her own thing. She has not produced anything. It is just her own imagination.
You have to produce all these things before the investigating officer. Let him have a look into it. Illi page number? Yeah, what does she say? Who is accused number 1 here?
Accused number 1 is petitioner.
Yeah.
All the accused are senior top level management. This is with regard to termination of her employment. As soon as she got the news of her termination, she filed same day, my lord. She files a sexual harassment. Post termination, she files a complaint. This is the crux of the matter, my lord. I request my lords to kindly
The mediation report from Davangere. Inna bandilva. This of the mediation report from Davangere mediation. Ishar Ahmad. They're not even taken process even once. Is there an interim order? In which time is granted to do the need? You notice on IA 1 of 21 as well as on the main division petition. Sorry.
I appear for petition in this matter, my lords. No settlement talks are done, my lords. Only deed is supposed to be retrieved, my lords. Weeks time may be granted, my lords.
This is a 2016 matter.
Please, my lord. Please, my lord. Settlement talks has been done, my lords. Only the deed is supposed to be retrieved from the bank.
Have you settled this question?
It is settled, my lords. Even the respondent has agreed for it. Only deed has to be retrieved and hand over to the respondent, my lords.
When will you get the DD? Tomorrow.
My lords, within a week, my lords. Maybe March 2nd week. Let the date be fixed on the March 2nd week, my lords. I'll report settlement.
Current counsel for the petitioner. What is the amount that has been paid?
26,50,000, my lords.
The learned counsel for the petitioner and the learned counsel for the respondent number 2 submits that the parties have settled the dispute at a sum of rupees 26.5 lakhs. So the learned counsel for the petitioner seeks time to furnish a demand draft for the said amount. List on 6th March as a last chance. In which Kamadi is directed to address arguments on the main matter.
Please, my lords. Grateful.
Deepak J. Venkatesh Ambati. Learned counsel for the petitioner has filed a memo to withdraw the petition. The memo is placed on record and the MK. Nandini case. What is the offense? Who are the accused?
Petitioner number 1 is brother-in-law. Number 2 and 3, they are permanent.
What stage the case is filed? At what stage the criminal petition is filed?
Filing the charge sheet.
Where is the charge sheet?
Page 18.
Page 18. Above the end. Who has spoken about your involvement? There is a complaint in it.
Page 31.
Both.
Ganda to
Everybody, please come to the relevant post.
When she is working as a professor in R&D, this prescription is the there is out of this setup, there is a virtual form. He was a drunkard that is on around and the for later respondent number 2 herself and shifted that just like property to petitioner number 1 husband. Then husband in turn shifted it to his mother. That site has to be given back. For that site, this people have that is the
Please read the complaint. Come to page number 32, third paragraph.
ನನ್ನ ಬರಬಾರದ ದಿನಾಂಕ 7/2016
What is there against 818? Page number? Go the end. Look, Anubhava Nagara is the place of the matrimonial home or is it a parental house? Any other cases are filed?
These allegations, but based on the petition Silence and what? In this case, for the one point. Respondent is possible argument, no representation is yet. Getting idea number 2, the girl will remain. This girl is below always. What parties are there? Now, my lord, the respondent number negotiation pending. He has also filed. Both in the case, reading 468 and 468. I number 2 and 3.
So that is what I am also telling you.
Number 2 and 3.
So that is what I am also asking him. Why are you wasting court's time? Yes. 18 on? No, she can't come up with an omnibus statement. ಪ್ರೇರೇಪಿಸುತ್ತಿದ್ದರು ಅಂದ್ರೆ ಏನು? It can be so vague. Correct, they are residing in Davangere. Basic question of prerapana. It should be able to prove the allegations against husband. What is one so called accused number 2 and 3 also. Who are the others? Is there any witness who has stated about this? I the past. Somebody must have been involved. Whether the mother of the complainant, brother of the complainant. They must have. Yeah, what have they mentioned? Let us see the first statement that was lodged. First statement alone and correct. Page number. Raj. ಎಲ್ಲಿ ಹೇಳ್ತಾರೆ ಇವ್ರ ಬಗ್ಗೆ A2 and A3 ಬಗ್ಗೆ ಏನು ಹೇಳ್ತಾರೆ? Page number? ಎಲ್ಲ ಆಮ್ನಿಬಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಷ್ಟೇ. ಎಲ್ಲ ಆಮ್ನಿಬಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್. There's no specific statements. They're not. Nobody has witnessed them. Enough. The petitioner has challenged the charge sheet. Petitioners have challenged. Petitioners have challenged the charge sheet filed against them for the offences punishable under section 498A, 506 IPC, read with section 3 and 4 of DP Act 1961. The respondent number 2 was the complainant and the wife of the petitioner number 1. She lodged a complaint on on 16/1/2017, accusing the petitioner number 1 of accusing the petitioner number 1 of violence in the marriage, also various acts, demands caused during the marriage. She also alleged that a site registered in her name was fraudulently transferred to the name of the petitioner number 1, who thereafter transferred it to his mother. She also alleged that the petitioners 2 and 3, being the brother-in-law, petition number 2 being the mother-in-law and petition number 3 being the sister-in-law, brother-in-law. Wife of Antakida Matte Mrityunjayinge, being the brother-in-law, were encouraging the petitioner number 1 to cause physical and mental cruelty to her. To stop. The prosecution recorded the statement of the mother and father of the respondent number 2, who all generally stated that the accused number 2 and 3 / petition number 2 and 3 in tandem, encourage the petitioner number 1 to harass the complainant / respondent number 2 to stop. It is this that is challenged by the petitioners, and they contend that as against the petitioners 2 and 3, there is no specific overt act linking them to the accused number 1 to stop. The learned counsel for the petitioner invited the attention of the court to the complaint lodged by respondent number 2 on 15/6/2017 16/6/2017, which discloses that except an omnibus statement that the accused number 2 and 3 were also encouraging the accused number 1. There was no specific incidents or acts to establish the complicity of the accused number 2 and 3, the offense. Full stop. He therefore, full stop. He further submitted that the complaint lodged by the respondent number 2 is a clear improvement of her case, since the said averments were never made in a GNWC number GNWC 92/2016, as well as in MC number 6/2016, filed by her for resolution. Raised. Accused respond number 2 file ಮಾಡಿದಲ್ಲಿ divorce. Divorce ತಿಳಿದ್ರೆ ಸೀಮಿಸ್ ಅಂತೀರಾ, ಅದ್ ನಂಬರ್ ಏನು? And CMS number 218/2015, which was filed under section 12 of the Protection of Women from Domestic Violence Act 2005. Full stop. He submitted that the respondent number 2 has now filed MC number 76/2021 for dissolution of the marriage, and thereto, she did not make out any specific instances involving the accused number 2 and 3. He therefore submitted that the accused number 2 and 3 are unnecessarily roped in to harass them. Full stop. The learned counsel, full stop. The learned HCGP, on the other hand, submitted that the complaint lodged by the respondent number 2 did bear a reference to the accused number 2 and 3, and also specific reference was made to accused number 2 and 3 that they exhorted the accused number 1 to recover back a site, to get a site reconveyed, get a site site standing in her name, reconveyed to the name of the petitioner, to the accused number 1. So we therefore submitted that there was sufficient material to establish the crime by the accused number 2 and 3. Next paragraph. The respondent number 2 / complainant, though served with the notice of the criminal of the notice of this petition, has chosen not to contest the petition. Next paragraph. Consider the submissions made by the learned counsel for the petitioners as well as learned HCGP. I have also perused the charge sheet and its contents. So the complaint has rightly contended by the learned counsel for the petitioners, except attributing physical and mental violence and cruelty by accused number 1. There are no assertions or accusations or overacts made by the complainant / respondent number 2 as against respondent petition accused number 2 and 3. Full stop. A perusal of the entire complaint only shows an omnibus statement made by the complainant / respondent number 2 that the accused number 2 and 3 were encouraging the accused number 1 to harass her. To stop. The complaint has not specifically mentioned incidents or events due to which, they could have caused mental and physical cruelty to the complainant. Full stop. a mere statement in the complaint or in the statement under section 161 of CRPC that accused number 2 and 3 were encouraging the accused number 1 to cause physical and mental cruelty would not be sufficient to prove the guilt of the accused number 2 and 3. Therefore, no purpose would be served in continuing the proceedings as against accused number 2 and 3 as the evidence collected by the prosecution cannot establish the guilt as against accused number 2 and 3. In that view of the matter, this criminal petition is allowed in part, and the criminal proceedings and the criminal prosecution of the accused number 2 and 3 in CC number 17339 of 2017 on the file of the 8th ACMM at Bangalore is quashed. However, the proceedings as against accused number 1 shall continue. Ahmad Yasik Shakila Banu. What is the offense? Number 12. Wife of the deceased, son of the deceased, Bazar Saab Ravara Maga Muhammad Skaullah. Father Nanu Baradu Kondo complaint.
Taking allegation against this law.
94. Page number? Huh? 80. What? Please. What?
The office is directed to register case against the the offense is punishable under this was true.
Yes.
This was. Instead you want to let us where we
Page number 60.
What about the you don't know our compliance may not private company. So my suggestion is that the testing of and medicine testing just possible. Not permitted.
Yes. Yeah. How is this justiciable? How can this be questioned?
Not like the CRPC is not authentic.
Yes.
Oh, yes. It gets verified. What there are? Yes. 58. We have evidence now.
Yes. ಆಗ್ಲೇ ಕಮಿಟ್ ಆಗಿದ್ಯಾ? ಕಮಿಟ್ ಆಗಿಲ್ಲ ಅಂತ Why? Please read. The power of the court under 319 is always there. That's
Yeah,
a different thing.
always there.
Correct. No, but where has the court taken cognizance? Court has not taken cognizance. It has only issued summons to you.
Yeah, it must have been. Everything has to go like
Yes.
the original jurisdiction. How to do the second court?
Yes.
And we need to. Mistakes have to be expected. Whether it is true or right, the legislature was required to take cognizance of that. It does settle that. Hearings of an offence can only be taken once. In the event, the legislature takes cognizance of the offence, then commit the case to the court of. The question of taking cognizance of the case. Thereafter, proceed. It's not applied. Cognizance is to be taken of the offence, could be taken either by the legislature or by the court of. Language of the system.
So you please read it. Cognizance is to be taken of the offence.
Could be taken either by the legislature or by the court. The language of section 1 clearly indicates that once the case is committed to the court of by the legislature, the court of section assumes original duty. All that goes to the assumption of duty. The origination is a 209 years, therefore have to be understood as the legislature playing a active role in committing to the court of section and finding from the court of section, case was triable by the court of section.
Please read the order impute.
Now it is directed to release the case.
No. Please read the content to the order.
That's from 80.
Yes.
Cognizance has come with complaint alleging the justice process of permitted the other. The complaint alleging from Mohammed Azhar, filling out the now as defeat, the victim was principal counselor of the complaint further alleges that the district has been to Bangalore from 2000. To obtain personal passport for the purpose of performing the information further Mohammed report. The company wanted to inform Mohammed after he is written on even that inform her that he is written the so far he is not written. Let us enter the What the health plan also the same, along with the clear to declare that for it is returned to Tamil and Tamil has that when are you without declaring that he is going to bring his permanent further to yes. Now, phone, mobile number also, ask the company to go here, confirm the volume. The place where unidentified headquarters info, also inform her to identify that whether the body comes to any one of relatives of the complainant. Complainant further says that thereafter, after the driving, but the headquarters of former Russia, then further anything.
Who are the accused in the charge sheet? Different people. As against this accused, the court has issued common sustainer. Where's the question of saying that it is yet to take cognizance against this accused? No section. Suppose if the court comes to the conclusion that it is this accused who has committed, would it not inquire into it? Yes.
Was the evidence of the complaint. Was recorded on 20. Complaint that was not so the whisper about the something.
Right, but what is mentioned in the complaint is that based on your statement that 7 others were involved, she lodges a complaint based on your say. Now she realizes that ನೀವೇ complaint ಮಾಡೋದು. Correct. Now she has realized that it is you who has committed the offense.
But made it clear to present well. But there was no whisper 319 money ಮಾಡಬಹುದಾಗಿತ್ತು.
319 ಮಾಡಬಹುದಾಗಿತ್ತು, correct, ಇಲ್ಲ ಅಂತಲ್ಲ.
So now
But whether the prosecution investigation has taken that angle,
ಹೋಗಿದ್ದಾರೆ ಮಾತಾಡಿದ್ದಾರೆ.
whether this accused or the petitioner was involved in the investigation. What is there to show? ಈ petitioner, whether he was involved in the investigation. Huh? No, I don't know. The petitioner, is it the sole petitioner or more than one? Whether you are involved in the investigation is a question. Adila, not even as cited as witnesses. The charge sheet is a charge sheet nodi. You are. Grant counsel for the petitioner seeks time to secure the charge sheet. Discount, yavat? Discount date. Seventh. They are arranging the work, sir. Let's put it in a short date. 6th March. Second is day after tomorrow. Tomorrow is extended till the next date of hearing. As a last chance, this one second. An hour.
Lauded by divorce wife. My own house. This filed in the year 2017. 2 years.
As I read the complaint as a part. Yes. Hmm.
And file on me. Here also we have on me with same allegations of that in dwelling house as far to my own house.
But it is the case of the petitioner that the respondent, who is his wife, had lodged a complaint of theft of what?
Theft of 30 lakh rupees every day.
Theft of jewelries. Theft of her jewelries valued at a sum of 30 lakhs. Such a complaint was lodged on 15/6/2017, when the petitioner and the respondent were separated by a decree of dissolution of marriage on 12/8/2015. Hence, all further proceedings in so and so are stayed. Please, Jafar. Huh? STM Prasad. STM Prasad passed away. Live. Which one, madam? Serial number? The learned counsel for the petitioner submits that the petition will be dismissed. Dismissed. Has not pressed. File a memo. What is your name? Srimati Nandini or Miss Nandini? Miss Nandini appearing for Mr. A.M. Somashekara submits that the petition may be dismissed as not pressed. So the submission is placed on record and the petition is dismissed as not pressed.
Your Lordship, in serial number 19, I appear on behalf of the petitioner, Your Lordship. Your Lordship, Rashmi Jadhav has been appointed as High Court Government Pleader, Your Lordship. So fresh wakalat needs to be filed, Your Lordship.
You file a memo of retirement, Mr.
Memo of it. We'll do the needful, Your Lordship, in a week's time.
Learned counsel for the petition.
There is interim order, Your Lordship. Interim order is there.
Learned counsel for the petitioner seeks time on the ground that the counsel for the petitioner is appointed as the High Court Government Pleader.
Yes, my High Court Government Pleader.
The last chance, 1 week's time is given to make appropriate arrangements. During which this petition shall stand, shall be disposed of based on the available material. If you want to grant, if not, 7th March.
Much obliged, Your Lordship.
M.K. Venkat Ramana. Yes.
One is directed to pay 2,000 rupees.
If they have given liberty by the appellate court,
He made time was on made time well. And the other than 1911 to 1911. Thereafter, on 17 we delay after the section.
no mediation, it was the divorce was disposed of.
Mediation.
ಏನಂತ Yes.
Married. They decide to do that. Then thereafter, she come back to India. She might pass days.
If she is happily residing in a foreign country, why will she come back to India? And why will she find? So therefore, the bottom line is they are not living together. So therefore, does she have any?
Left, yeah. And she filed 498. Very important argument.
Correct, Mr. This is an order passed under section 29 of the Domestic Violence Act. It is a matter for trial. If trial is for
They're not done. Continually.
the Sessions Court has not ordered that. You please have a look at the order. Appellant is directed to deposit 50% of the interim order amount, that is 25,000 per month from time to time. Is confirmed in part. The order passed by the magistrate is confirmed in part. The appellant is that magistrate passed an order directing you to pay maintenance of 50,000 rupees per month. That is reduced from 50,000 to rupees 25,000, and see the liberty again given. Till further orders that may be made by the trial court on taking preliminary evidence and inquiry in the trial. Trial agilwa. Will direct the trial court to expedite it. 2015. Will request the trial court to expedite. Work out.
Yes, give me. And there are the balancing.
Is there a possibility of settlement? You please put your heads together and see whether you can settle it. Yes, Mr. Pundika, why do you want to unnecessarily waste your time in litigation? And great, please tell us. Finish your thali. Let me complete. You are not even listening to what I say. You are arguing your own point. What I am trying to tell you is, if you can't see eye to eye, why don't you settle it? You take some money and be done with it. Some alimony. I tested. What is your expectation? Mr. What is your expectation?
They are demanding because it is selling huge money, selling more than 5 lakhs.
What do you want? What do you want? Please tell us.
No, 10 years. 10 years. And before that, we already tried a second higher petition against. That is more than this. Now, subsequently, something was suppressed due to this court with regard to. Subsequently, after the passing of this order, my lord, inquiry was made and they taken order was Sessions Court. Sessions Court.
10 lakhs. He's not making payment.
So when there is litigation, there is going to be fire. There is going to be fire. It will not be smooth, isn't it? Even if it is going to be smooth, people are there which who do not allow it to be smooth. Correct? Please come out with some solution, Mr. Why are you proliferating the problem? You know, see, we do not know who is at fault. The court can never come to a conclusion and say that this party is at fault in the marriage. Therefore, you must have made a decision that it is impossible for you to live with this man. You must have come to a conclusion that it is impossible for you to live with this man. Do away with him. Tell him that what is that you want. Yes, Mr.
Whatever they have said.
Who is this man?
Whatever the asset has been transferred to my father, it is so that on half of the document. So, it is sure. My answer, my brother is there. Everybody is there. And because of her,
Yes, you want to settle.
75 lakhs.
Correct. You want to settle. What is your income tax returns? Common.
2 lakhs. 2 lakhs.
2 lakhs per month. Per annum. What do you do? Can you please tell what is that you are doing? Don't argue. You appointed a lawyer to argue. Please tell what you are doing. Are you able to pay 50 lakhs? Can you pay 50 lakhs? $21.25 lakhs. So please come up with some figure. How much are you willing to pay? When was that? When was that, Mr.? 2 months back. 21.25 lakhs. 2 months back. Yes. Right, 21.25 is arrears ಬಗ್ಗೆ. Is it a fact? So Pundit Aisha, but I don't know. Correct rate 21.25 ಬಗ್ಗೆ ಹೇಳಿ first. Sir, did you understand what he said? Why don't you answer his? No, why don't you answer him whether it was accepted? Yes. Yes. He said, what is there to show? Mister, what is there to show that 21.25 lakhs was the figure that was accepted by the party? Is there any document? Yes. Yes.
See, let him say no. Whether the parties agreed or not, if he say no, I don't know what.
Yes.
Because that's why I called my party. Because I not able.
Yes, Mr. Can you please argue the matter? Yes. ಅದಕ್ಕೆಲ್ಲ ಬೇರೆ ತರೀಕಾ ಇದೆ. ಆ ತರೀಕಾ ಉಪಯೋಗಿಸ್ರಿ. You file an application GNWC.
I totally modify you.
You're not allowing visitation rights to the child.
And in that idea was right.
So you want the maintenance for the child. You don't allow access to the
No,
child.
that is not true. Check for.
Let him spend time with the child. Let him spend time with the child. Let him forge a relationship. I don't comply the orders passed to the court for visitation, then you're not entitled to maintenance. You honor the court order, then we'll also direct them to pay the maintenance. If you don't honor court's order, why should you be granted maintenance? You want everything to be according to Yavat Martha. We are going to direct. Exam after the exam. So if you don't allow access to the child, allow access to the child, we direct the police.
Keep the party custody. The party
Venkatramana, ಮಧ್ಯದಲ್ಲಿ ಏನ್ರಿ ಬೆಂಕಿ ಹಚ್ಚೋದು ಇದು? Wait for your turn. Let him finish.
Because the exam, just I will contact to get the child and let the respondent before this order.
Let them come up. Let them come up with a solution, not a problem. Don't proliferate the problem. Don't increase the problem for yourself and for him. Come up with some solution, workable solution. Don't ask for the moon. I am on Barakenri. Let her come. The learn counsel for the petition and respondent. It's time to
tomorrow.
You please deposit 25,000 prakara continue. We'll direct the trial court to expedite the case within the next maybe about 1 year or so. Alivaru kattlebeku ನೀವು. You're not paid in charity, mister. You're paid to your wife and your son. So therefore, don't say that you've done some charity. Continue to pay whatever is the arrears. When will you deposit? When will you deposit? To explore the possibility of the settlement. Discount now. Next day to our target. 6th March. March. Don't execute the order. The learned counsel for the respondent. The respondent is directed not to execute the order passed by the appellate court in criminal appeal number 2 and so till the next date of hearing. Yes, but you know, settlement act try ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಪೇಮೆಂಟ್ ಮಾಡೋದಿಲ್ಲ 25 ಲಕ್ಷ 50 ಲಕ್ಷ ಆದ್ರೆ why should you pay? Arrears ಇರ್ಲಿ. Arrears. Then it will be a bounty. Next. Don't execute. The next state of hearing, don't execute. You waited for the last 6 years.
Oh, yes, like that, now the area.
It be, mister, if there's going to be a settlement, why you want to spark it? Don't spark the process of a settlement. The other one, let's say deposit money, in the end, the settlement. Then you'll ask for 50 lakhs, is it? Then you'll ask for 50 lakhs for settlement. Be sensible, Mr. Pundikar. Sir, you ask, you want 30, Mr. 13 lakhs you have put to, 13 lakhs you have put to, settlement you have to trying to be practical, Mr. But why not to be practical? Yes. I know, I will consider. Till the next day, no world is going to collapse. Heavens are not going to fall apart. Accused number? Yes, Mr. What is the role of accused number 2 and 3 in this case? Sir, this is 138. This is a summary proceeding. How do you involve accused number 2 and 3? Interim, admit interim stay of all further proceedings in CC number 16191 of 2017 on the file of the Chief Metropolitan Magistrate at Bangalore, insofar as the petitioners are concerned. However, the proceedings against the accused number 1 shall continue. Rajuddin. Office of Distribution, for vacating space. There is no representation for the respondent. The Office of Distribution on IA number 1 of 2019 is not complete. First file is IA 1 of 23. 1 of 23 is filed by whom? One of 23 is filed by you, Mr. Tajuddin. IA 1 of 23 is filed by you. What is IA 1 of 23 is what I am asking you. Please comply the office of. The copy is not served until the source. This who appears for Mr. B. Keshav Kumar. B. Keshav Kumar. There is no representation. There is no representation for the respondent. There is no stay. There is some stay here. Mark. Let the case go on. Because we do not know what is the stage of the proceedings before the trial court. I don't want to halt it. Please argue. Next. No, sir, unless I know what is the status of the proceedings before the trial court. Let it happen. What is the proceedings under Domestic Violence Act? Let it go on.
The argument we have inserted in it, I have to argue in the matter. Yes.
Yes. Sorry, sir. Sorry. It's correct. Even narrowly. What is this case about? Password. Run Joseph.
Then agreement is at least by nature.
Section B is the letter of undertaking.
Subject oral agreement is still, I am another. Age about also, we hereby undertake that I will actually know. I have reached an oral agreement with Mrs. Brandy, aged about 40 years, wife of Sri Kandegowda, the complaint. The sale of the above scheduled premises, consideration of both. Entire terms and modalities of the sale shall be put on paper by way of second. The executive between the parties. Each community will hereby agree. The draft of sale shall be kept ready. Tentatively subject to the convenience of the party. Please notice, because as a token of commitment, the execution of sale is given by way of leading numbers. Drawn on Karnataka Bank, regular access. It is also submitted that as a security to the advance amount, receive the post-dated check. Given to the prospectus, it shall be returned back to Mrs. Nanda at the time of execution of the deed. Now, suppressing this, a complaint is filed, which will also to get at page 24 by Mr. Chandregowda. Saying that there has been cheating that has occurred. You will see that we have done our bit memos and exchange drafts of the sale agreement at page 48. Duly memos acknowledged by the complainant's wife.
But virtually you are reducing the High Court to an investigating officer.
No, Melons.
Virtually you are reducing the High Court to that.
No, Melons.
What else is it? What else is it?
Melons here.
So you want the High Court to look into the documents intersection between the parties and give a decision whether the complaint is right or wrong.
Melons,
Virtually you are asking us to conduct an investigation.
please see only the complaint, the suppression of the agreement by whatever way, suppression of that. Second, Melons, all of a sudden, numbers 2 and 3, who are the children of the petitioner number 1 are made accused. No allegations against them. No, Melons, this is entirely a civil issue. He has to go to a civil court and he has to seek refund of that amount.
Where's the complaint? Where's the complaint?
Complaint was on page 24. No allegations or ingredients of section 420.
Please read the complaint.
Please, subject complaint in respect to betrayal and cheating and selling on property. I am residing at the address along with my family and doing the job of one Srimati and Manga, age introduced to me by one of my relations for it set the house very numbers. And 9 for a sale consideration of rupees
on the same day, I paid rupees 1 lakh in cash. Thereafter, she started avoiding the agreement of sale. On inquiry, she told that the price of house has been underquoted and she would execute the agreement of sale. If I agree to make rupees 1.70 lakh. This was told by her on 5/12/2017, and on the said date, I was 1.5 lakh. Very greedy numbers. As a security for the said amount, Srimati Nanda has issued a check for rupees 10 lakh, not online. Then after 26/12, she promised to execute the agreement of sale in respect of the said. I think I should pay these on receipt of which she agreed to hand over. Thereafter, in spite of expiry of money, she did not execute the agreement of sale. I made further inquiry and learned that on the
Have you received this 10 lakhs?
we have received
Have you refunded it?
no memos. In fact, they have filed separate section 138 proceedings which are pending in this matter. In spite of that, memos, they have filed a separate complaint.
Correct, Mr. You have sold the property to somebody else.
No memos, I believe it's now.
Whatever it is not sold to them.
It is not so.
So you still continue to hold their 10 lakhs with you. Whatever, 10 or 11.
Complaint is respect.
So therefore, why do you expect the High Court to look into all these things and decide whether you are at fault, he is at fault? Why should we do that? It is a job of the investigating officer. Place all these documents before him. Correct. But the fact that you received 10 lakhs by demand draft is not in dispute.
It's not a dispute, so that stands forfeited. As per the agreement.
What forfeited?
So as per the agreement, it's
Where is the agreement?
35.
Wait, please wait. Let him say, let him point. Where is the clause for forfeiture?
It says as a token of commitment, I was just paid this, and thereafter was the second last paragraph. It shall be returned at the time of execution of.
So where is the return of this 10 lakhs? Have you returned it?
No, we have not executed the agreement. We send them a legal notice, asking them to come forward and execute the agreement. And we say if they do not, it will be forfeited.
Where have you mentioned that it will be forfeited?
From the word forfeiture.
So therefore, you cannot do that. You cannot do that.
Because it says at the time of handing over,
Yes.
at the time of execution of the agreement.
This thing would have been to return their money and deal with your property. You don't return their money and you still deal with your property. What does it amount? See, if you're a genuine person, the court will come to your aid. You take their money, you don't return their money. Obviously, what will he do?
Probably initiate proceedings.
All right.
Because no purpose in anyway, but not.
You repay the 10 lakhs along with some amount of compensation. Will direct him to close all proceedings. When? Not 15th. 13th. Grant counsel for the petitioner. Subject to seek instructions whether the petitioner can put an end to all litigation by paying up the amount received from the respondent number 2. This month 13th. Ramchandra Desu. Anantpura. And the other is filed in? Which was the first complaint? First complaint was? Anantpur. Yes, Shiva Reddy. Yes, Mr. Is it the same complaint? Then let this be transferred to the station in Anantpur. Judgment is further, this will be treated as further information. Anthony, into the yeah, Anthony, take Anthony. Huh? The one, then first FIR is lodged in Anapura. If it's on the same government or same allegations, why should the two police stations lodge criminal prosecution to the same allegations? Let it be treated as a further information. Who appears for the respondent number 2? ಇಲ್ಲಿ ಇದೆ ಅನಂತಪುರ ಕಂಪ್ಲೇಂಟ್ ಇಲ್ಲಿ page number 30. Please read the complaint. Please read. This is filed by the father. Complaint now lodged. But complaint is also examined there. Rani is examined. Could this proceedings continue here? So she's already before the court in Anantapur. To admit they have all further proceedings in CC number. Yeah. Admit. Mohan Kumar. Yeah. There is a Mohan Kumar. Huh? Huh? Let it come, got some inconvenience for it. Huh? Yes. Tenth, 8th, 8th Raja, 14th. Next, Okay, for the respondent two, you for the complaint. No,
This is a case where my lords are taking the advantage of the Indian law. And the members that got for the entire person, they are out of the areas of that property. One was in the inside.
if you give it to her, it is hers. You give the money to her, it is hers.
These last members, but it's not keeping well as on that day.
Is she alive? Is she alive? Therefore, you have to file an appropriate suit for recovery if you want. But fully admit, stay of all further proceedings is number one. ಇದು ಲೈನ್ ಅಡ್ಮಿಟ್ ಆಗಿದೆ. Yes, admit, stay, yes. You want. Here. 31.1. Huh? If you want time, I can adjourn it. Want it to be taken some other day. Huh? 3 weeks, it's ruled out, Mr. It is day after day. Can be best. The people in the US, they work professionally, right? They work more professional than us. So therefore, no question, no question. Which one is the eighth is the seventh? 1 week. Not necessary. We'll take the documents as it is. Discount 7. Fine. Gavali. Anjana CS is directed to accept notice for respondent number 2 in the first paragraph. Officer is directed to show his or her name, the cause list. List on 7th March. Devaraj. The accused are private person. So, what is the complaint? Holders of weighing instrument.
Against the third party agents are being then they are collecting the allegation.
Who are you? How many of you? Where are the licenses? Annexure C series. What is the allegation against these people?
The allegations that is only that no correct that by obtaining price that amount is collected for
So far as these petitioners are concerned, what is the allegation?
there is no allegation.
What is the if they got license, if they are not conducting the business according to the license, what has to be done? What has to be done against them? Where is the allegation made against them? They are also involved in the offense. Counsel for the respondent number 1 weeks time, list on 7th March. Gopal huh? The petitions 2 to 5. Who appears for petition number 1? Hi there. Yes. The learned counsel for the petition, Mr. Gopal Murthy C, has filed a memo of retirement. Submits as since the petition is already represented by another counsel, he may be permitted to retire. The memo is placed on record and is permitted to retire. Office is asked to delete his name to cause list. Three 23, 326, 504, 506. What are the injuries? What are the injuries? An injuries in what are the injuries? Mr.? Yes, Mr. You got it. Charge sheet ಹಾಕಿದ್ರು charge sheet ಆದ್ಮೇಲೆ wound certificate ಇರಲ್ವಾ? Sir, the charge sheet they won't be wound certificate, is it? How will they justify 326 without a wound certificate? Don't make this careless submissions. While you ನೋಡಿಲ್ಲ ಅಷ್ಟೇ. Charge sheet ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. Where is the head of the charge sheet? Dr. Mahesh, ಸಪ್ತಗಿರಿ ಆಸ್ಪತ್ರೆ ಚಿಕ್ಕಬಾಣವರ ಅವ್ರು ಬಂದು ಏನ್ ಹೇಳ್ತಾರೆ? He has to say something about the wounds, isn't it? Mata, don't make these submissions that there is no wound certificate. Yes, Mr. S. Please read the statement of this lady, Hemavati, page 38. ಮಧ್ಯಭಾಗಕ್ಕೆ ದೊಣ್ಣೆಯನ್ನು ಪಡೆದುಕೊಂಡು ನಮ್ಮ ಮಾವನ ಹಣೆ ಮತ್ತು ತಲೆಯ ಮಧ್ಯಭಾಗಕ್ಕೆ ಮತ್ತು ಎಡತೋಳಿಗೆ ದೊಣ್ಣೆಯಿಂದ ಹೊಡೆದು ರಕ್ತಪಡಿಸಿದನು. ಇಬ್ಬರಿಗೂ ಪೆಟ್ಟು ಬಿದ್ದುದು ನೋಡಿ ಬಿಡಿಸಿಕೊಳ್ಳುವುದರಿಂದ ನನ್ನ either you sort it out at the village level itself. There are injuries, Mr. Complaint ಅಲ್ಲಿ ಏನಿದೆ ನೋಡೋಣ. ಓದಿ.
ಕೇಸ್ ಹಾಕಿರುತ್ತೆ ಆದರೂ ಸಹ ಅವರು ಜಾರಿ ಮಾಡಿರುತ್ತೆ ಅವರ ಮಗಳು ಕೆಲಸ
Yeah, allegation here. ಯಾವ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊತೀರಿ ಊರಲ್ಲೆಲ್ಲ ಹಿಂಗ್ ಜಗಳ ಮಾಡ್ಕೋಬೇಕು ಅವ್ರು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ತಾರೆ ಕಳೆದೇನ ಖರ್ಚೇನ ಮಾಡಿ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ತೀವಿ trying to explore the possibility of settlement this month, 14th March. 14th March is extended. This on 14th March as the last chance. Tomorrow granted is extended to the next year. It's Gopal Krishna. Yaru, who is it? What is your name? You will appear. Huh? Mr. Shiv Shankar. Mr. Shiv Shankar. Full initial. Mr. Shiv Shankar submits. Huh? ಏನಿಲ್ಲ ಏನು ತೀರೋಗಿದ್ದಾರೆ ಅಂತ ಏನು ನಾವು ಸ್ವಲ್ಪ Mr. Shiv Shankar notes that the branch counsel Sri Gopal Krishna has expired, that he would hear on behalf of the respondent. This on the office is directed to show his name that from this on 14th March. Here Nagaraj. Yes, Mr. Let us see what is his case. ವಿಷಯವನ್ನು ಗಮನಕ್ಕೆ ತೆಗೆದುಕೊಂಡ ಯಾವುದೇ ರೀತಿ ಮಾಡಿಲ್ಲ. When was this complaint launched?
Complaint is lodged on
6/2/2012. It is immediately after purchasing.
Yes, further statement is
Java, when will you sit and work out and settle this? Java could not work, inspect ಮಾಡ್ರಿ. Please. 2009 ಅಲ್ಲಿ ಏನು incident?
Further statement ಇದೆ.
Can you lift install ಮಾಡಿದ್ ಯಾವಾಗ?
Install ಮಾಡಿರೋ 2009. 2009 ಅಲ್ಲಿ further statement ಅಲ್ಲಿ ಅವರು ಹೇಳ್ತಾರೆ. Page number ಮನ್ನಾಡ.
2012 ಅಲ್ಲಿ ಖರೀದಿಸಿದ್ದು ಅಂತಿದೆ.
Because our second page.
But there's a further complaint.
Page number 11. After the complaint.
Page number 11.
Page number 11.
Huh?
Page number 11.
Yes.
Second paragraph. 2009 ಆಗಸ್ಟ್ ತಿಂಗಳಿನಲ್ಲಿ ದಯಾಕರ್ ಅವರು ಮೇಲ್ಕಂಡ ನಂಬರ್ 8 ಪ್ರಯತ್ನ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಗಾರ್ಡನ್ ಬಡಾವಣೆ ಆಶ್ರಯ ಕಂಪನಿ ತುಂಬಾ ಚೆನ್ನಾಗಿದೆ, ಚೆನ್ನಾಗಿ ವರ್ಕ್ ಆಗುತ್ತೆ ಅಂತ ಒಂದು ಮ್ಯಾನ್ಯುಯಲ್ ಸ್ಥಾಪಿಸಿಕೊಳ್ಳಲು ಆಗುತ್ತೆ. 26/8/2011 2011 ನಮ್ಮ ಬಿಲ್ಲಿಂಗ್ ಆಟೋಮೆಟಿಕ್ ಕಳವಳಿಕೆ ಲೆಟರ್ ನೀಡಿರುತ್ತಾರೆ. ಆಟೋಮೆಟಿಕ್ ಅಳವಡಿಸಿದ ನಂತರ ಅದರಲ್ಲಿ ನಿಂತು ಹೋಗಬೇಕು. 16/5/2012
When will you inspect and rectify? ಅದೆಲ್ಲ ಬಿಡ್ಲಿ, ಯಾವತ್ತು rectify ಮಾಡ್ತೀರಿ? When will you inspect? Company ಇಲ್ಲ ಅಂದ್ರೆ face the process. If you want peace, buy peace. Mr. An individual comes to your door, whatever he quote, he pays, and he doesn't get the product. Service illa, product illa. Why will the lift fall down 4 times? I check ಮಾಡಿ. When will you visit? When will you visit? ನೀವು ಮಾಡ್ತಿರೋ ಬೇರೆಯವ್ರ ಹತ್ರ ಮಾಡಿಸ್ತಿರೋ ಮಾಡಿಸಿ, ಬಟ್ ಲಿಫ್ಟ್ ಹೋಗು. ಇಲ್ಲೋಗಿದೆ. So that is your problem. You have sold the lift. You dispute that. Can you face the prosecution?
Single document has been experts.
Trial, matters of trial. These are all matters of trial. Either you sort it out or you face the prosecution. Yarade iradari.
Civil in nature.
2012 issue, even in 2023, your factory is closed. Where will he go? You kota, ದುಡ್ಡು ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ lift on ಹೋಗಿ. Please do that at least. Please do that. So you're dealing with a lift where humans will travel or use it, not travel, use it. Dabbanta bidda satadar yarri job there. And if he's operating a unit, industrial unit, tomorrow there will be labor unrest. What will he do with it? Either you pay, take back your lift, let him install another lift. No compromise on these things. Maybe there are some technical issues. But how will you find justice for himself? 12 years. 12 years have gone by. Have you examined it? You hope not. Once you lodge it. Yes. What is the report? You hope after the complaint was filed, did you go? Did you inspect? Yavag ಮಾಡಿದ್ರು? ಎಲ್ಲಿದೆ? What is the material? What is the material to show that you have inspected, you have rectified, you have repaired? Yeah, material kudi. If you don't do it, then you have to pay up to your nose. That's a matter for trial. That's a matter for trial, Mr. How can the court, High Court sitting in 482 decide whether correct nut hakidra, correct bolt hakidra, sudha itta, sudha irlilva? How will the court decide? You have cheated him by assuring a particular standard of lift, which you are not provided. Either you settle it by taking back the lift, paying back the money, or rectify the lift properly, so that all litigations are put an end to. ನೀವು ಯೋಚನೆ ಮಾಡಿ ಯಾವತ್ತು ಅಂತ ಹೇಳಿ 2 weeks ಎಲ್ಲ ಕೊಡೋದಿಲ್ಲ. 11% for the petitioner. Submits that he will seek instructions from the petitioner. Let him do whatever he wants. Learn counsel for the petitioner. Sir, he will not repair it. He will send somebody. Is he the one who is going to repair it? You pay back his money. Throw his money on his face. Take your lift back. I'll do it or put video. How will a consumer, Mr. A consumer of a product, he can't be assured of the quality. He can't be assured of the quality for the money that he pays. Yav marthi helri. The counsel for the petitioner seeks time to ascertain whether the petitioner can amicably settle the dispute with the respondent number 2. List on 14th March. List as a last chance, list on 14th March. Yes, Prakasham Party. Will admit they of all further proceedings in PC number 78 of 2020 on the file of the signature in James State Hall. So far the petition is concerned. Dana was That's not only the petitioner. With respect to the offences under 4(1) and 2 of the MMDR Act. Yes.
Petitioner 83-year-old. It is present in the
He's on the deathbed.
Under section 125 CRPC also proceedings were initiated by the respondent. Which are attained finally. By the efficiency.
Yeah, ಏನ್ ಮಾಡ್ತೀವಿ? Correct. What income will you have? Why can't you claim maintenance from your children? "75-year-old man, do you think he'll be counted in the family? He'll be counted only for the purpose of.
Give the particular share of the land back.
How much will you pay her?
Because now presently I am paying 4,000. Let us give.
Where is she residing?
She is now residing with the elder son.
Elder son.
Yes.
ಇನ್ನೆಲ್ಲಿದ್ರು? ಒಬ್ಬನೇ ಇರ್ಬೇಕು ಅಂದ್ರೆ ತಲೆಗನ್ ಸೂರ್ ಇರ್ಬೇಕಲ್ಲ. ಎಲ್ಲಿ ಯಾರ ಮನೆ? ಯಾರು ಮನೆಯ ಯಾವ ಪೋರ್ಷನ್ ನಲ್ಲಿ? He is living there along with the son. Along with the son, she is living. I think you are living in a house which belongs to your son in a portion, right? Correct. Yes. ನಾಲ್ಕು ಸಾವಿರ ರೂಪಾಯಿ ಕೊಡ್ತಾ ಇದಾರಲ್ಲ. What is your son doing? What is his? How old are you? How old are you?
Now
62 years, sir. Indian ಖರ್ಚು. Indian medical health issues ಇದೆಯಾ? ಏನಾದ್ರು ಮೆಡಿಕಲ್ ಇಶ್ಯೂಸ್ ಇದೆಯಾ? ಏನು? ಓಲ್ಡ್ ಏಜ್ ಕಾಯಿಲೆ ಬರೋದು ಓಲ್ಡ್ ಏಜ್ ಅಲ್ಲಿ ಏನ್ ಕಾಯಿಲೆ ಅಂತ ಹೇಳಿ. Getting almost about 150 rupees per day. ಊಟ ಫ್ರೀ, ಮನೆ ಫ್ರೀ, ಕರೆಂಟ್ ಫ್ರೀ. ಮತ್ತೆ ಮಗ ಕೊಡ್ತಾ ಇಲ್ವಾ? ಮಗನಿಗೆ ಯಾರು ಊಟ ಹಾಕ್ತಾರೆ? Miami close 6,000. 6,000.
11,500. Already, I like the kind of increase. Because again, they have already started. Considering this particular.
How much is passed now? So 10 plus 4.
8,000.
So 12,000 rupees.
We need total 8,000.
Including that 4,000 which was granted in 125. Just 2,000 ಕಡಿಮೆ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. 6,000. Close it. ಯಾವ್ದು memo joint memo ಯಾವ್ದು? Counsel for the petition and the respondent submits that. ಎಲ್ಲ ಸೇರಿ ಎಲ್ಲ ಬರ್ಬಿಟ್ಟು ಜಾಯಿಂಟ್ ಮೆಮೋ ಎಲ್ಲ ಬರೀರಿ. At the rate of 6,000 ಎಷ್ಟು arrears ಇದೆ ಎಲ್ಲ ಬರೀ. Learn counsel for the petitioner and the respondent. You will advise the parties to accept the sum of rupees 6,000 as maintenance from the date of the petition till the date of the petition, full stop. You learn counsel for the petitioner and respondent will stand to report a settlement. Discount on that. We know Raman. So what is this case, man? Why will it come to? What is challenged here? What is challenged here?
In detail, examination. There was a dispute pertaining to the petition. The examination was not met.
This is so this is a summary trial. Is there any order passed under 143 to convert it into a summons trial? Then
The incorrected matter.
but what was the order challenge before the trial, the revision court? Questioning the correctness and legality of the order dated 5/3/2021 passed by the magistrate on a memo dated 11/1/21. Yes, what had to be compared, madam?
All the documents were not properly examined.
Correct. Where is the order passed by the magistrate? Initially, referring the matter to 45. Where is the order?
Yeah.
53. So where is the order allowing the application section 45? Where is that order? Where is that order? What had to be compared with what?
All the documents
We have to pass on that order. You have a copy of that order? The colleague is having that copy of the order. Why are you not looking at it? The colleague is showing that order. They are simply ignoring it deliberately. That's okay, but where is that order, madam? What had to be compared with what? In any case, the revisional court ought to have appreciated that is similar to revisions filed with the petition are allowed by the same. And therefore, no separate inferences fabrication. This is against an application order, application section 45. Correct, the application is allowed now. It is sent, referred. Therefore, you please produce that order to see what had to be compared with what. No, you want something else to be compared with something else. That is a memo. Then yes. All is available. He wants to nip you in the butt. Will not hear him.
Before we respond to this, tell me this around the different certain people to university.
Yes. Hello. Prakshubda.
Security guard ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಅಥವಾ ನನಗೆ
Nothing is mentioned about this matter.
Including security staff who are allegedly outside the campus, staff, this statement, which that came money. All executive, yes,
Why is the fee?
I have been arranged that.
$25.
There were 82 witnesses who were examined, including security staff, security head, lieutenant, who was everybody.
Yes. Page 186. Yes.
Dated 17/11/2020. Permit to read. Not the statement. Very good ವಿಷಯದಲ್ಲಿ last one. ವಿಳಾಸದಲ್ಲಿ ವಾಸ. And the learning center ಕಾರ್ಯಕ್ರಮವಾಗುವುದು. Create ಮಾಡಬಹುದು.
Almost.
Well, given the 10/9/2000. Something here. So, आप इधर ये लगा रहे थे सारे मतलब ये शर्मा अगर ये भी कुछ सारे तो हम सारे ये पता नहीं जैसा मार्केट मार्केट पर लोग हमारे
Was anything recovered from you?
This is my personal blood. You have to be. So the pattern is
ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ನಿಮ್ ಮೊಬೈಲ್ ಏನೋ ಸೀಸ್ ಆಗಿದೆ. ಎಲ್ಲಿದೆ? ಎಲ್ಲಿದೆ? ಮತ್ತೆ ನಾಗರಾಜು ಆರೋಪಿ ಮೊಬೈಲ್ ಅಮ್ಮ. Where's the mobile? This is one. Delhi CCTV idea. Is it part of the charge sheet? Okay, mobile amount also pension amount.
You are not together and so that you had the period.
Who else has seen about this man? K. Ravi Kumar ಬಗ್ಗೆ ಬೇರೆ ಯಾರು ನೋಡಿದ್ರು? But this man was inside the campus. How did he see what's happening outside? He saw in the CCTV, is it? Where is he found in this? Where is he found in these many photographs? ಇದರಲ್ಲಿ ಎಲ್ಲಿದ್ದಾರೆ ಇವನು? Where is this Ravi Kumar? Huh? Three photographs ಅಲ್ಲಿ ಎಲ್ಲಿದ್ದಾರೆ? Where is he? How to tell? See whether he is found any of these photographs. CD is part of the charge sheet. Huh? ಅಲ್ಲ ತಿಳಿಸಿ ಏನು A1 this Ravikumar A25 and ಏನಿದೆ apart from the statement find out what are the other materials that you have. Further investigation against whom? All the accused person. ಅಲ್ಲಿ ಇದೆಲ್ಲ A25 ಮೊಬೈಲ್ ಎಲ್ಲ ಸೀಸ್ ಆಗಿದೆ ಅಂತೆಲ್ಲ ನೋಡ್ದಂಗ ಆಯ್ತಲ್ಲ. Has the mobile of this accused number 25 has it been seized? Huh?
Charge-sheet-ಅಲ್ಲಿ A25 ತಲೆ ನಡೆಸಿಕೊಂಡಿದ್ದಾರೆ ಅಂತ
But there's one more Ravi Kumar. Accused number 23.
These things are not better. Not to visualize the case of and it's very acute. I'm not certainly not trying to criticize. On my life, personally on my life, Partinagar police in this case has taken a serious.
Why are you involving yourself in this case?
Because of all these things,
No,
serious note of that. There is a detailed exam. I'm just basing.
No, but why do you want to be a part of this investigation?
Not being a part of the
No, that is right, but why do you want to be a part of this whole case? If there's a threat on your life, please, no, don't invite risk again.
This honorable court took a serious note and they entered the apology before the court. That it's very great grief, my lord, I place it before the honor. An incident, my lord, is happening in 2019. The entire incident happened in 2019. But a case 2019. Investigation was concluded. Where a detailed charge was placed in the and by the degree officer and routine. The matter is at the trial stage. Recently, after all these cases, a month ago, they were come and file a petition, making stark allegations against the lawyer, saying that the lawyer gave this condemning acts of this very accused person, saying that you are literally attacking the fraternity. And before the ink dried, some attacks were launched on this. And our lady colleagues, which was taken a serious note by the coordinator. There's a case registered in Karnataka Proceedings. The investigation is under progress. This very petition has, but I have learned that this is important. This is all learned.
Anyway, let us restrict ourselves to this case. Let us restrict ourselves to this case. So I am saying, let us restrict ourselves to this case.
The case that there is lack of material, there is lack of evidence. They'll have to go. They'll have to go. If there is that case, but I believe that I am not accounted papers. I don't know.
You notice the issue on New York, but
Only when the case, the petition hinges on the ground that there is lack of evidence against me. Then I'll have to do this issue.
yes, Mr. Find out what all material you have collected against this accused. Find out. ಯಾವಾಗ ಹೇಳ್ತೀರಿ? ಯಾವಾಗ? What is the stage now? Further investigation is going on. For what? Yeah, what? Yeah. Till 14th, what is, please tell me. If something is going to happen, we'll stay. You're already on bail. To learn CGP 6 times. It's on 14th March. Star Kumar. Yes. Star Kumar. 20th special offer. Who filed the suit? No. Yes. Correct? Now here the application reject. Then what happened? Yes, then what happened? What is where have we mentioned? Where have we mentioned in the plaint that the land is acquired? Third. Yes, Mr. The Land Acquisition Office has not discussed the compensation. See for reference.
I am seeking much prior to acquisition, the land was acquired by me, 24 acres of land was acquired. By way of CND dated 2024. Thereafter, he is not having a right to acquire. He is executed in CND that he is like for an extent of 1 acre, including the acre. Possession of the word, I am in possession of the property. I am in possession of the property. No, my possession was not. Now they are saying that it is after acquisition, the land acquisition. It is not.
Should be referred to the court if there is no dispute. There is a dispute.
1966.
Have you lodged a complaint?
Yes. I like an objection to that.
Go ahead. If it is not referred, what is your relief? If it is not referred, what is your relief?
I'm seeking declaration of it. Not prior to acquisition, my right was there. But that I'm seeking declaration of it. That's the owner duty of it.
If he does not do it, what should you do? The land is already acquired. So how will you be declared as the owner?
For what? For one.
Look at the defendants. Who are the defendants? Who are the defendants? Correct, but who is the defendant? Number 1. 1 and 2, who are they? They are Taser. Have you looked at section 30 of the land acquisition? ನೋಡಿದಿರಾ? ನೋಡ್ದೆ ಇಷ್ಟೊಂದೆಲ್ಲ ವಾದ ಮಾಡ್ತಿದ್ರು.
What the thing is, my right.
Without even knowing what is the scope of an inquiry in the section 30, you are arguing. Please go to section 30, 31. Put it. Go to section 30, 31. Allogi, if you already before the land, the reference court or before the land, it has to be done.
Section 30, 32 of Partition, we objection.
Where is the question of declaring you to be the owner when the land is acquired?
Declaration based on the.
So you should claim that you are entitled for the compensation. You can't seek for declaration of your ownership.
When 1960 itself is admitted, I am the owner of the. Then
this is to be decided by the land acquisition court. In a reference under section 30 or 31. If the court has not referred, file a petition. Again, or will refer this itself to the LAC reference and idea. We'll refer the suit to that LAC court itself. With LAC number kodi. So we are not deciding the case on merits, for God's sake. Why don't you understand the scope of the proceeding? We are not going to decide the.
No, my lord.
The accepting and real. 2022 revision petition. Hard sheet is tapayide.
How many times you do that?
ಆಗಲೇ 3 ಸತಿ ಆಗಿದೆ. 4, 5 ಸತಿ ನೀವು ಟೈಮ್ ತಗೊಂಡಿದ್ದೀರಾ. 6 ರೆಸ್ಪಾಂಡೆಂಟ್ 7 ಸತಿ ಟೈಮ್ ತಗೊಂಡಿದ್ದೀರಾ. And you are saying ಒಂದೇ ಸತಿ.
Last time, before last time ನಾನು ನೋಡಿದ್ದೀನಿ. Before last time, I was.
7 ಸತಿ ಇದೆಯಪ್ಪ. Don't challenge everything.
ಸಂಬಂಧ ತಗೊಂಡ್ಬಿಡ್ತೀನಿ.
Learn something from the respondent each time to ascertain whether the respondent has sought for reference in the section 13 schedule of the Land Acquisition Act. So we have a twist on. Very good. 6th March. ಎಲ್ಲಿ ಯಾವತ್ತಿದು? ಯಾರು ಇಲ್ವಾ? 9th March. The last chance 9th March. ಷಣ್ಮುಗಪ್ಪ, ಚಂದ್ರಪ್ಪ. What is the suit for? Declaration regarding what?
This is declaring the plaintiff as the owners as the register. He did it 25 times. Application. This declaration after the suit.
No. 1676 or
This is partition.
defense had filed.
This is the pending principle. This is plaintiff. Well, amendment of seek amendment of the return state. The application is a treasure of 51. But filing the return statement, it will not go to the appeals. Subsequently, it makes an application. The inspection, keep on.
The suit may ultimately be dismissed. ನೀವೇ ಗೆಲ್ಬಹುದು. So ultimately you will win the case. We'll assume that you will win the case. The law is 7 Rule 11 only plaint has to be sealed. ಅಲ್ಲಿಂದ ಇಲ್ಲಿಂದ ಪಕ್ಕದಿಂದ ಅಲ್ಲಿಂದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ತಂದು ಹಾಕ್ಬಿಟ್ಟು you can't. That is a law. There are hundreds and thousands of decisions on that. You only look at the plaint, nothing more.
Even in the places.
Whatever is mentioned in the plaint, which according to you does not meet the requirement of 6 out of 7 Rule 11A.
11.
Yes.
And the plaintiff.
Cannot both the suits to be tried together.
This will the order pass.
Because they are not concerned with it.
Because the citation is already attached.
Right? We are not concerned. How can the court give a finding on the will?
Yes.
Right? 6 rule 17 only.
So, all the factors. Plenty of food.
Yes.
He contains the.
It's a question of fact. Let the court decide. It's a matter of fact. Limitation is a question of fact. Let the court decide. When he came to know all this things, let an issue be framed to that effect.
All these factors.
Please come at people.
Lordship, audio is muted, Lordship.
Yes. Ah. Let us see the plaint. If there is no cause of action, we will allow the petition. Plaint notice. 24. Yes, please. Page number 29. Ah. Is it before the same court? Then we'll direct both the suits to be decided together. There's one judgment of Justice Honorable Justice Suraj Govindraj on the question of limitation. Particularly in a partition suit. Yes, both. Paragraph number 9 ilvalla illi. Subparagraph.
We have stated about instead of this is in fact. All of action, allows one to suppress the setback. In fact, amendment application. So that is that have to be rejected. What is the 10 years of 10 years?
The will ಬಗ್ಗೆ will the property gets transferred, correct? Yes or no? It gets transferred. It gets transferred. Subject to proof of will. Because you are challenging it now, these wills have to be decided in one forum or the other. Correct, partition suit application that was rejected. Anyway, he has filed an application, the partition suit for amendment, that is rejected. Some court will have to decide about the legality of the will. Some court will have to decide at some point in time. Otherwise, there will be a clog on your title later. The partition suit decree, I think it will. There will be a clog on title because the will is there, executed.
There is no cause of it. So what is cause of action? Only for the person filing this suit. Never happened. So cause of action.
It's a revision petition is filed by the defendants. Voice number P88 of 2018 on the file of the fourth additional senior civil judge in the World District, Bangalore. Challenging an order dated 8/7/2022, by which an application filed by them at Order 7 Rule 11 of A and D CPC was rejected. Suit in voice number 1588 of 2018 was filed for a declaration that the plaintiffs are the owners of the suits. Plaintiff or plaintiffs are. Plaintiff is the owner of the suitable properties having succeeded in terms of a registered will dated 25/10/1994 and for consequential relief of injunction. To stop. The plaintiff claimed that the plaintiff's father had bequeathed half extent in survey number 8/5 on the southern side, survey number 3/A, 7/3A, and 7/3B towards the southern side, on the southern side. Survey number 20/3 on the southern side, 23/1 on the eastern side, survey number 6/4 on the eastern side, survey number 34 on the eastern side, survey number 59/1 on the southern side at Gantiganahalli, Yelahanka, Bangalore North Taluk. And survey number 28 on the southern side in favor of the plaintiff to stop. Likewise, he had bequeathed some properties in favor of his daughters. Land bearing survey number 96/2 on the southern side, 86/1 on the southern side in terms of a will dated 25/10/1994. To stop. He also claimed that his uncle had bequeathed certain properties in Gantiganahalli, Yelahanka, Bangalore North Taluk. And that the land bearing survey number 28 situated at Lakshmi Sagara village was allotted to towards his share. Stop. He contended that pursuant to a oral partition, subsequent to a partition, the defendant's mother filed an application for transfer of revenue records to her name, and that the revenue records transferred to her name. She thereafter executed a gift deed dated 8/12/2005 in favor of her daughter, that is the defendant number 1. Full stop. He claimed that it was mentioned in the gift deed that it was the responsibility of the defendant number 1 to take care of the defendant number 2. Stop. Plaintiff claimed that in terms of the will of his father and his uncle, dated 25/10/1994, the plaintiff became the absolute owner of the suitful properties, while the defendants were the owners of the land bearing survey number 96/2 and 86/1 of Gantiganahalli. Stuff. He alleged that the the defendant's mother demanded to share the properties held by the plaintiff. Stop. Okay, stop. This was escalated before the panchayat of the village, where a settlement was arrived at, in terms of which the plaintiff agreed to give away 4 acres in survey number 6/4. To give away 4 acres. 4 acres in survey number 6/4, 59/1, 86/1A, and 23/1 of Gantiganahalli, consequent to which a partition was reduced into writing on 15/1/2002. Full stop. The defendants thereafter filed a suit for partition in OS number 1676 of 2006. Sorry. Thereafter, the plaintiff filed a suit in OS number 1676/2006. And then, the defendants filed a suit for partition separate possession in respect of the suit properties against the plaintiff in OS number 1676 of 2006. So stop. The said suit was contested by the plaintiff. Later, he filed an application under Order 6/17 for amendment of the written statement to claim that his father and his uncle had executed a will dated 25/10/1994, which were duly registered. So the said application was contested by the defendant's hearing, and the same was rejected in terms of the order dated 23/6/2017. Stop. The plaintiff therefore filed the present suit in OS number 1588 of 2018 for a declaration that he was the owner of the suitful properties by virtue of the will dated 25/10/1994, executed by his father and his uncle, and for consequential relief. Next part. The defendants entered appearance and filed their written statement. They also filed an application on Order 7 Rule 11A and D of the Code of Civil Procedure, contending that the plaintiff did not make out a cause of action and that the suit was barred by the law of limitation. Stop. The defendants claim that the will was dated 25/10/1994. And the plaintiff made no effort to seek a declaration of his title in terms of the will dated 25/10/1994 from the year 1994 till the year 2018, when OS number 1588 of 2018 was filed. It was intended in the application that the claim did not disclose a clear cause of action, and what was mentioned in paragraph number 14 of the plaint was an ingenious way of drafting the plaint to bring it within the law of limitation. Stop. it is also contended that the plaintiff did admit that the cause of action arose when the defendants objected to the application filed under Order 6-17 invoice number 1676 of 2006 that no such will was executed in favor of the plaintiff. Therefore, it was contended that the suit filed after suit is filed later. Suit filed later is barred by the law of limitation. Stop. The trial court, after considering the objections to the application and after hearing the parties, rejected the application in terms of the impugned order on the ground that the plaintiff did set out a clear cause of action for the relief of declaration of title and for consequential injunction. It also held that the question of limitation, the aspect of limitation is a mixed question of law and fact. And the plaintiff did mention in the plaint that the cause of action arose when the defendants delayed the execution of the will dated 1/3/2016. Full stop. Being agreed by the said order, the present revision petition is filed. Next paragraph. The Learned Counsel for the defendants submitted that the plaintiff did not even whisper about the will dated 25/10/1994 in the written statement filed in invoice number 1676 of 2006. Full stop. He therefore submits that the subsequent plaint filed in invoice number 1588 of 2018 was a clear invention by the plaintiff to lay an unlawful claim, though there was no cause of action for the same. Stop. Insofar as the question of the application being barred under Order 7 Rule 11D, he contends that the will set up propounded by the plaintiff was dated 25/10/1994, and that the father of the plaintiff died. Father of the plaintiff died on has he mentioned the date anywhere? Father of the plaintiff died on 1987. Father of the plaintiff died somewhere during 1997, while his uncle also died. Yavaga, Sampangappa. While his uncle also died thereafter. However, no steps were taken from the year 1997 and thereafter to the year 2018 to establish the validity of the will, valid execution of the will dated 25/10/1994. He therefore submits that the suit is clearly barred by the law of limitation. Per contra, the learned senior counsel representing the plaintiff submitted that the plaintiff did disclose a cause of action and the same was not imaginary and not a clever piece of drafting as contended by the defendants, but was genuine in as much as the wills dated 25/10/1994 were duly registered in accordance with law, and therefore there was no question of plaintiff concocting or propounding a will to stop. He further submits that the relief of declaration of title was based on the will dated 25/10/1994. Therefore, there was sufficient cause of action for the plaintiff. So far as the question of limitation is concerned, he submitted that the plaintiff had indeed succeeded to the suit properties under the wills dated 25/10/1994, and that the need for seeking declaration of title to the suit property based on the will dated 25/10/1994 arose in view of the objection filed by the defendants in OS 1676 of 2006, denying the lawful execution of the will and its existence. He therefore submitted that the suit filed in the year 2018 was well within limitation, as the right to file as the limitation began within 3 years from the date of the cause of action. 3 years from the date of the accrual of the cause of action, which in the present case was in the year 2016. He therefore submits that the trial court has rightly considered the above. It has rightly held that the application cannot be considered at the threshold. It is not in dispute that the plaintiff made an attempt to place on record the wills dated 25/10/1994 in OS number 1676 of 2006 by way of an application for amendment of the registry. The said application was opposed by the defendants herein, contended that the wills dated 25/10/1994 were not validly executed and also disputed its existence. Stop. Following the above, the plaintiff sought for declaration of his title to the suit's properties based on the will dated 25/10/1994. Full stop. The plaint also sets out the cause of action as a cause of action where it is stated that the cause of action of the suit arose on the date of denial of the lawful execution of the will and its existence. Full stop. Therefore, the contention of the defendants that the suit was barred under section 7 Rule 11A is not justified. Similarly, the contention that the suit was barred by the law of limitation is also not established in as much as the defendants for the first time denied the lawful execution of the will in the year 2016, while the plaint itself was filed in the year 2018. Therefore, the suit was not barred by the law of limitation. It was, on the face of it, not barred by the law of limitation. So the trial court has rightly considered the application and has rightly rejected. The court has considered the application and has rightly rejected it. So there is no merit in this revision petition, the same is dismissed. Before parting, it is necessary to note that the defendants have already filed a suit in OS number 1676 of 2006, which concerns the properties which are the subject matter of the present suit in OS number 1588 of 2018. It is therefore appropriate that both these suits are tried by the same court. And the same court, and by recording common evidence and by disposing them of by a common judgment. To stop. In view of the above, this revision petition is dismissed. The trial court is directed. The suit in OS number 1588 of 2008 presently pending on the file of is 4th additional Senior Civil Judge, Bangalore Rural District, is transferred to the Principal Senior Civil Judge, Bangalore Rural District, to be tried along with OS number 1676 of 2006. To stop. The trial court shall record common evidence in OS number 1676 of 2006 and pass a common judgment disposing of both the suits. So since the original proceedings are initiated in the year 2006, the trial court is directed to expedite the suit, dispose it off within a period of 1 year. Within a period of 1 year from the date of receipt of a certified copy of this order. AV Amarnath. Ah. Thousand? Commercial or residential? The house.
Notice was issued from the start of court, but the evidence recorded and the pleadings recorded. And a memo calculation was filed, showing that 3,57,000 yes.
The lease is admitted. Lease is admitted.
This is admitted, no use. For an academic, they more than 2 lakhs farmers.
Yes,
It has to go to the next file. This one, I think, memo calculation.
all right.
Usually, simple manipulation, like 2 lakhs, 10,000. It's for 3 lakhs, 2,000, we don't have.
What are the suit prayers? What are the suit prayers?
The HRC petition,
Let him complete. This is his petition. He has paid the court fee. You have not paid any court fee. So let us listen.
the HRC petition, they show the ISS 97. The HRC code. When it comes to small class code, we should have really separate the
What is the rate of rent?
7,500, they have 7,000. ಮಗು 5 ತಿಂಗಳು ಮಗು ಮೇಲೆ
ಏನೋ ಆಗ್ಲಿ ಸರ್ ಪ್ಲೀಸ್ was vacated. This is vacated.
ಓಪನ್ ಕೋರ್ಟಲ್ಲಿ ಟೀ ತಗೊಳ್ಳಿಲ್ಲ ಈ ಹೈಕೋರ್ಟಲ್ಲಿ ಬಂದಿಲ್ಲ ಹೈಕೋರ್ಟಲ್ಲಿ
ಕೊಡಿ ಗೊತ್ತಾಯ್ತಾ
election is there now the others are going to be claiming is clear to some and actually good with giving for
then use it is
Right, you what? Tenant has handed over the key. Tenant has
So when was this transferred to the small trust?
21.
21, isn't it?
21.
Let us see.
Evidence.
From the year 5/11/2019 till the date of transfer of this case, what will be the arrears of rent? Madam, it is not validly presented before the court having jurisdiction. 2019 you filed the case.
2020.
2020.
Petition was filed on 18
correct? Claiming what? ನಿಮಿಷ ತಾಳ್ರಿ ನಿಮ್ದಾಯ್ತು. For arrears of rent of from 5/11/19 to 5/11/20, correct? What is the arrears? 97,500. Now the case is transferred to the small class court. What is the date of transfer?
June 12, 2021.
2/12/2021. So another 97,500.
It's 2 lakh.
ಎಷ್ಟಾಯ್ತು ಅಲ್ಲಿಗೆ? 1,95,000. And for the month of December, another 7,500. It will come to 2,02,500. So you are entitled to claim 2,02,500 as on the date of filing the case before the small class court.
You have filed an application for 151 CPC, it is addressed on it.
Yes.
That is the application on which
151.
151 of CPC.
Where's the application?
Give you an order for that.
Yes, please read. Yes, Mr. Admitted rent has to be paid.
Yes, sir, let us take.
Deposit, no, 1 lakh deposit, less money balance 42,000 per tax. I was deposit 42,000, I will.
3,57,155 is the arrears of rent.
Because I think the government claim for getting is different matter, they are not prepared it. Things are vacated it. I'm not occupying the house.
At what stage this application was filed? Madam, at what stage this application was filed? Is it after evidence?
Evidence is not given.
After evidence this was done.
It is
Permit to make the submission, there is all the long submission that is made.
If you want to take this kind of titles, please sit down.
Well, admittedly, evidence was running with the HRD petition matter. The matter was posted for cross with PWR. The tenant did not cross-examine the witness. The cross-examination was taken as nil, and the matter was posted. Notice the court very clearly held that no notice issued. The parties are here that what to be before the court.
Yes, yes.
Tenant, you not appear before the court. Even after conversion, more statement was. I application of CPC, seeking areas of rent method. And now with that, when I admittedly I wish to notice what to be page 27 of the order sheet.
Yes. Yes, what is your case? What is there to show that you have paid the rent? What is there to show you have paid the rent? from the year 2020 and onwards, after the case was filed before the HR.
First person that this, I am not for the.
What is, you can contest the jurisdiction, but you are bound to pay the rent.
Yes, sir.
Have you paid the rent is the question.
I think the data,
Admitted rent alla, rent as per the agreement.
Okay. I believe. Once it is 7,500 and it comes around 2 lakh. Simple multiplication.
Usually 5% for every year. What is it, madam? 5% escalation for every year. How does it become 3,57,000?
I'm going to read. My both side and claim the documents are claim for the rent agreement which shows that in the year 2015. The rent was agreed at the rate 7,000 per month, but it was agreed after 11 months because it will increase every year towards the rent. Exhibit fee to legal notification 2009. The duty served on the defendant on 26/2009. Para number 3 of the notice, it is clearly stated that the amount from September 2019 is 1,26,000. The Lata that is every month is every month is worth it. Another notice ask the detailed order as to how for the period from 1 month.
We are not on that. When you filed the case before the small causes court in HMC, your claim was the rate of rent was 7,500 per month. That is your claim. That is your claim. Correct. From 7,500 rupees per month from the date of the petition before the in HRC, what will be the rate, rent?
Whether if we go on that line.
Go in whichever lane you want to.
Before this ongoing court, petitioner had deposited a sum of ₹50,000. After deducting all that, the amount due to me would be 1,42,000.
Yes.
The tenant is deciding in the premises from 2012. At least.
Yes, Mr. 123 is what is due. 123 is what is due. Pay it and close it.
142,500.
123.
Yeah. On that advance.
Minus for it. ಲೆಕ್ಕ ಮಾಡಿ ಹೇಳಿ. So 7,000, forget 5% escalation. Pay at the rate of 7,500 rupees. Sir, you please pay it at 7. That is the admitted rent. You please pay it at the admitted rate of rent. How much? The 7,500 in the history of the time.
As far as this calculation, there is no individual that's why if they give it a proper calculation.
I'll give you the proper calculation now itself.
Taking the calculation will against that.
When did you vacate? When did you hand over the key of the petition scheduled premises to the respondent?
For this matter, what will be the asset?
Give you the order sheet for the order.
Very clearly shows.
I'm worried what will happen if you, both of you argue a constitutional matter. Suits your premises and is ready to hand over the key to the petitioner advocate, but defendant is not present, nor any key is handed over today.
There
Hence
are
will
going
come.
to be conduct of the party even before the trial court.
When was the key handed? Amarnath,
These are.
And now- Don't blame me that conduct and all. Your conduct as a first job disease. The law should operate properly.
you see this, counsel for the defendant filed a memo that is vacated the suit's property on 3/8/2022 and is ready to hand over the key to the petitioner's advocate. But defendant is not present, nor any key is handed over today. Correct. Our counsel name client illanta. Name client, but defendant andre yaar sir. Name client to defendant.
There are some errors in recording not because of that. I'm not mentioning now.
When did you hand over the key before this? In January. You pay rent for 48 months. Yes.
Right, actually,
That is I.
Just to 1 lakh, 125 is deposited, the deposit,
1 lakh will be deposited.
1 lakh.
3,000. If the amount paid for the ordinance.
That's quite a lot of, it's virtually coming to 2 lakh, 2,10,000.
as I'm finding your SC student, it was more than 2 lakh, this court has only 2
So there is a arrears, admit, I don't know why you are getting lost, Mr. Amarnathan. 2 lakhs is the jurisdiction for filing a case before the small cause court, that's it. In this case, the jurisdiction was there, because the amount of, the case was transferred on 2/12/2021. So even if you say 3 years of rent, it comes to about 1,95,000 rupees. Sorry, 2 years of rent, 1,95,000, which is again less than 2 lakhs. Please apply. No. Mr. Amarnathan cannot be saying this. Sorry. Amarnath, you can't be saying this. Sorry. No. Already rent ಎಷ್ಟು ಅಂತ ನಿಮ್ಗೆ ಹೇಳಕ್ ಆಗಲ್ವೇನ್ರಿ? We are only fighting over. So you have already handed over the key. Where's the question of jurisdiction, mister? You already handed over the key to the owner. Where's the question of jurisdiction? You want to conduct an operation on dead body? This is Amarnath. You're making a mountain of a molehill. It's what I can only say. Making a mountain out of a molehill. What is the arrears servant of me? Mister, it's only arithmetic calculation. If you do not know, you please ask a student of 5th or 6th standard, they can multiply.
That's what they did.
Well ಮಾಡಿದ್ದೀರಾ? Well ಮಾಡಿದ್ದೀರಾ? 3,57,000 ತಗೊಳ್ಳಲ್ರಿ. 3,57,000 ತಗೊಳ್ಳ. ಮಾಡಿ ಸರ್, ಪ್ಲೀಸ್ ಮಾಡಿ ಸರ್, ಮಾಡಿ ಈಗ್ಲೇನೆ. ನಿಮಗೆ ಕ್ಯಾಲ್ಕುಲೇಟರ್ ಕೊಡ್ರಿ ಅವ್ರ ಕ್ಯಾಲ್ಕುಲೇಟರ್. ಪ್ಲೀಸ್ ಮಾಡಿ. Now that you wasted half an hour, I don't want to waste any further time. Please calculate at the rate of 7,500. At the rate of 7,500 per month from. What is this, Mr. Amarnathan? measurement ಮಾಡಿ calculation ತಂದಿಲ್ಲ. No purpose is served. ನೋಡಿ ಬರ್ಕೊಳ್ಳಿ ಇಲ್ಲ ಬರ್ಕೊಳ್ಳಿ please pull out your pen. ಅದು ಪ್ರೆಸ್ ಮಾಡಿ ಓಪನ್ ಮಾಡಿ ಪೆನ್. 5/11/2019 5/11/2019 to 5/11/2020 is 1 year. Correct? 1 year. 5/11/2020 to 5/11/2021 is another 1 year. 5/11/21 to 5/11/22 is another 1 year. ಮಾಡಿ ಸರ್, ನಮ್ಗೆ ನಾವು ಎಲ್ಲ ಅರ್ಥಮೆಟಿಕ್ಸ್ ಎಲ್ಲ ಓದ್ಕೊಂಡ್ ಬಂದಿರೋದು. 19 to 20, 20 to 21, 21 to 22 ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಸರ್? 3 ವರ್ಷ ಆಯ್ತು. ಕರೆಕ್ಟಾ? ನವೆಂಬರ್, ಡಿಸೆಂಬರ್, ಜನವರಿ 2 ತಿಂಗಳು ಪ್ಲಸ್ 2 months ಹಾಕಿ 36 plus 2 is 38 months. 38 into 7,500 ಎಷ್ಟಾಯ್ತು? ಎಸ್ಕಲೇಷನ್ ಆಗ್ತಿಲ್ಲ ಸರ್. 7,500. ನಿಮ್ಮ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದೀರಾ? Have you filed any statement? ಹಾಕಿಲ್ಲ. So therefore you admitted that. That is your lookout, sir. 2,85,000 minus 1,50,000. 1,35,000 is the arrears of rent that you have to pay. You want to take it or leave it? When will you pay and close it? Any discounts, madam? One time offer. All the, it is aged about 8 years, one time offer ಕೊಟ್ಕೊಡ್ಬೇಕು. ನಾಳೆ ತಂದು ಕೊಡಿ, take it. 1 lakh close.
Now it's not ready for exit.
Then madam will have to file a suit for recovery. Execution, madam, you have to go in search of him. It's not, it is impossible.
We kindly have it tomorrow, my lord. I think there's an instruction.
You never handled an execution, have you? The saying is, the travails of a decree holder starts from the day he gets a decree. Correct? That is the observation made by the Supreme Court. The moment he gets a decree, the difficulty starts then. So therefore, don't face the difficulty. Why 80-year-old man should face difficulty? ನಾಳೆ ತಂದ್ಕೊಡ್ರಿ 1 ಲಕ್ಷ ಕ್ಲೋಸ್ ಮಾಡೋಣ. ಕರ್ಸೋದಲ್ಲ, ತಂದ್ಕೊಡಿ. Please get 1 lakh.
Page 37 of the order sheet.
Everything is over.
Submission. That to be enhanced. At page 37, the order enhancement and what is the rate? You mean that the ready to settle at the rate of 7,000. Even with that.
I don't know what is the stamp paper drawn on which the agreement is drawn. You want to go into the nitty-gritties of it, we'll go into it. No, please tell us. Stamp paper, ಎಷ್ಟು stamp paper will draw ಮಾಡಿದ್ರು agreement?
There the agreement is not.
Not much. And you want to say 5% escalation.
No, but even assuming we leave about the enhancement, they need to cut rate of 7,000.
No, I'm been telling the same thing, arrears of rent only. ಯಾವಾಗ? Grant counsel for the petitioner submits that will seek instructions regarding the arrears of rent payable to the respondent. List on Friday.
contains that formation.
However, overcome the presumption. ಹೇಳ್ಬಿಟ್ಟು ಬೇರೆ ಜಾಗ ಇದೆ ಹೇಳಿ. ಹೌದು.
Lot of things. But we at least need this. Number 6. Best one. There is no passage. See the description. East by private, west by private, north by the
The execution ನೋಡ್ಕೊತಾರೆ ಬಿಡಿ. Let it be decided in the execution. Right, while executing the warrant, delivery warrant, the bailiff consider all this. Whether property can be identified, not identified. Don't worry about the order. Let him reserve liberty for it or.
there exists. And yes, right, for this reason. The contention raised. Item law or the part of. They can say father security. Always it. And what accept this. If this receipt is taken into consideration, the petition cannot be filed against you. The petition is filed against the this is also a glitching document. But they have produced certain rate receipts. Like the sugar. He can also.
I issued a reply to the notice.
These are notices are not received. But right question will not ask. I can see the legal notice.
Yeah, NCR. All for records. So let us get the record. Then you should take it there. All for records. Oh, you are jumping. Correct, Mr. Don't execute, or you undertake that you not execute. Don't execute till the next state of hearing. You make a mention or will stop you from executing. Should you not look into the records? Yes or no? So this exercise is 2021 na yavaga? 18. Get the documents. In Bangalore illi. Discount. Discount. Huh? Ninth March. Interim order granted is extended to the next. Yes, ma'am. No, but no, what is challenged here? What is challenged here?
I am challenging because in this is a population, submit not available. Beyond that, all these are
No, what is challenged in this petition? What is challenged in this petition? Your application under section 127 was dismissed. That is challenged here.
my son. They go to the directors.
How old is your son now?
Only for he born on 6/20, I'm not born. And stop making the other one maintenance of 2000 rupees per granted. Sometimes it's still is 73 of 2014. But granted 3,000 to the son and 10,000 to me. Maintenance. Stop making the 3,000 of such from the gate. We need to send people. Thank you.
When will you make the payment of 10,000 plus 3,000? No, if the court stops you from paying the maintenance, please wait, madam, please wait. What is the order? Yes, sir. Where is the order? Pritam Sharma. $10,000 per month to the first petitioner and 3,000 per month to the second petitioner from the date of this petition. The second petitioner is entitled to maintenance at the said rate till he attains majority. What about this? What about this 10,000?
10,000 is being paid.
File a memo of calculation. Please file a memo of calculation. Please file a memo of calculation.
Today morning also ascertained to my client that has been paid.
The learned counsel for the petitioner. Madam, please file a memo of calculation. For God's sake, madam, you don't make a calculation. Just pull something from the cap and say that it is not paid. And he says everything is paid. Who has to be believed? Make a calculation. Make some homework. The learned counsel for the petitioner submits that the respondent has paid to deposit the maintenance at the rate of 10,000 per month to the petitioner. Stop. The learned counsel for the respondent submits that he has deposited the maintenance till date. So the counsel for the petitioner and the respondent are directed to furnish a memo of calculation indicating the amount of rent payable. Yes, amount of rent, amount of maintenance payable. Based on when will you do it? Tomorrow. Any date. You do whatever you want, but We are listing the matter tomorrow at your request. If it is not done, we will have to impose cost tomorrow. Number 2 now. Ah. For the petitioners in seal number 1, 6 times discount. Even nearly. There is no representation for the petitioner, though it is called twice in a day. Where is Mr. Jeevan? He's always on his legs. Discount. Vijayta R. Naik. Srikanth NV. This Vijayta R. Naik. There is no representation for the petitioner, though it is called twice in the day. Discount. Next. Shafiq. This point has remained done.
So the complaint filed on June 3, 2018. Then by number 2 against the petitioner.
423.
427, 504, 506.
This is the complaint.
Page number 18, complaint against attempt of illegal trespass and yeah, that is a problem. It is deep by the result to be most of the yes. Simply to look how
What is the ground? What is the ground for challenge?
complaint in 2018. Complaint, I said, this was treated as the NCR. And closed. Again, very same incident, he got a present complaint, I said, he got a complaint of 7, 8 people. Take them, take them, we turn from Basa to one from Nigeria and one from the regular procedure. First, as was mentioned yesterday, the people of the trial and the related.
Yes, Mr. What has happened thereafter? After the was over, what has happened?
Sir, it is MPR code. Again, same, is narrated same, 8/3/2018 incident or quite a 1 month complaint. Before that, what this complaint was filed on 8/3/2018. Filed it on plate number 23. This was filed by the respondent against the petitioner on 20/3/2018. This suit for injunction filed against the petitioner. The respondent number 2. 8/3/2018 complaint was filed. 30/3/2018 the issue is suit against the petitioner for injunction.
Who is fine?
Suit is filed on 30/3/2018 page number 31. The date is
Yeah,
there.
I think. What happened?
The suit is going on. So again, the very same events in the 8/3/2018 quite a 1 month complaint on 7/8.
ಆಗಿದೆಯಾ ಇಲ್ವಾ?
On 7/8/2019, that is
The representation. Yeah, who appears in that suit? Please serve the lawyer who appears in the. The legal counsel for the petitioner is granted to serve a copy of the writ petition to Mr. Venkatesh Prasad or Sri Satish Reddy, Sri Hanuma Gowda and Kiran Gowda, who represents the respondent number 2 invoice number 102 of 2018. List on. Yes, more. You missed the bus, madam. You got the extension. 45 only. No, you should wait for your turn. Should wait for your turn. I'm in the midst of another matter. Don't take us for granted, madam, please, for God's sake. No, it's all right. If you miss the bus, you should wait for the next bus. You can't simply barge in and make a submission. Sorry. We respect you, madam. You should also learn to respect us. Huh? 45 interim order granted release extended to the next date of hearing. Now to Vijay Tanai, interim order granted release extended to the next. I sit up to 5:45, 6 o'clock. I listen to all your voice, and you people don't maintain minimum courtesy, minimum decency in the court. You barge in and make a submission when somebody else is making. That's not correct. Don't take the court for granted. Go to next court ring. It's 46. Legal counsel for the petitioner. Can this tomorrow. चंद्रशेखर के हाँ has it been settled or not? Legal counsel for the petitioner seeks time as a last chance response also. Interim order granted is extended till the next date of hearing. It's however made clear that no adjournment shall be granted on the next date. Come on. Yes, sir. Yes. About 66 is already quashed. 66 is already quashed.
This is for, when you report of, time thereafter, yeah. 24. 41.
Page 40.
We are ready to go to page 45. Level 16. Yeah.
I don't even know what is a complaint. Have a look at the complaint.
The complaint is not. Thereafter, page 45, the extract.
Let us see the complaint first. Is that annexure C? Please read. ಕನ್ನಡ ಬರಲ್ವಾ? ಭಾರತದ ರಾಷ್ಟ್ರಪತಿ ಗುರುತ್ವಾಗ ಮಾಡಲಾಗಿದೆ.
ಇಮೇಲ್ ಐಡಿಯನ್ನು ಚೆಕ್ ಮಾಡಿ ಅದೇ ಐಡಿಯನ್ನು ಈ ಒತ್ತಾಯ ಮಾಡಿ ಅದರ
Yes, please. What is the ground on which the proceedings are challenged? What is Q1 LP? Q1 LP is what is Q1 LP, sir? I'm referring to the chart sheet. Clause number 16, which you just now read.
Yeah.
What is Q1 LP? Digital evidence storage media. Mark. ಇಲ್ವಂತಲ್ರಿ ರಾಮುಲು ಅನ್ನೋದು ಇಲ್ವೇ ಇಲ್ವಂತೆ. Correct, but you look at the complaint says that somebody has used this email ID ramulu.stumc@gmail.com ಎಂಬ ಇಮೇಲ್ ಐಡಿಯನ್ನು ಸೃಷ್ಟಿ ಮಾಡಿ ಇದೇ ಐಡಿ ಮೂಲಕ ನಾವು ಕೆಲಸ ಮಾಡುತ್ತಿರುವ ಸಂಸ್ಥೆ. So ಇಲ್ಲಿ ಹೇಳೋದು no reference of ramulu.stumc and the documents marked D1 to D9 could be found in the suspected digital evidence storage media. There is the report of the forensic expert, the report in. What is that Q1? On sealed cloth packet. Page 8. Q1 LP. Integrated. There's nothing. What number is it? This petition is filed by the accused. CC number 969, 969 of 2016. Of 2016 on the file of the first civil judge in JMFT Kolar. Challenging the cognizance taken by the trial court for the offences punishable under section 66 and 66A of the Information Technology Act, that with section 201 of IPC. Next paragraph. The case of the prosecution is that CW1 lodged a complaint. CW1 lodged a written information on 29/10/2014 that he was employed as a medical superintendent and deputy medical. The medical ಏನಾಗಿರೋದು? Medical. So what is he, Sri Ramulu? Medical superintendent. While another lady, Srimati Sheila, is employed as a deputy medical superintendent at R.L. Jalappa Medical Hospital. Full stop. The complainant received a letter from the Medical Council of India. Sorry, the principal of R.L. Jalappa Medical College received a letter dated 27/10/2014 from the Administrator Medical Council of India. And on perusal of the said letter, it was found that the same was addressed by the principal, by the accused, by the principal. Yeah, on perusal, it was found that the complainant and Srimati Sheila, it was found that several complaints against the complainant and Srimati Sheila were Srimati Sheila were forwarded from an email ID ramulu.stumc@gmail.com. So they claim that the allegations made in the mail related to their services at Devaraj Aris Medical College, related to administrative issues when they were employed at Devaraj Aris Medical College. So they claim that they had not created the email ID ramulu.stumc@gmail.com, and that some third parties, in order to besmirch their image, had created a false email ID and had submitted a complaint to the Medical Council of India. So based on this complaint, the jurisdictional police registered crime number 142 of 2014. Stop. On what basis they came to know? The investigating officer traced the IP address from where the email was created and seized the laptop of the petitioner, which was allegedly used to create the email ID, and subjected it to examination, subjected to forensic examination by the Central Forensic Science Laboratory, Hyderabad. Stop. After receiving the report of the Forensic Science Laboratory and recording the statement of the witnesses, the investigating officer filed a charge sheet complaining the commission of offences punishable on section 66 and 66A of the Information Technology Act. 66C and 201 of the Information Technology Act. Stop. 66C and 201 of 66C of the Information Technology Act and section 201 of the Indian Penal Code. Stop. The trial court took cognizance. Trial court has taken cognizance. For what offences? The trial court took cognizance of the offences punishable under section . Yes. Yeah, offensive. Huh? Cognizance taken for which offense? 66 of the IT Act, regular section 201 of IPC. Being agreed by the same, the present petition is filed. The learned senior counsel representing the petitioner submits that the report of the Central Science Laboratory discloses that there is nothing incriminating found in the laptop belonging to the petitioner. He invited the attention of the court to the report where it is specifically mentioned that there is no reference of double inverted comma ramulu.stumc@gmail.com and the documents marked at exhibit D1, marked D1 to D9 could not be found in the suspected digital evidence storage media marked as Q1LP. Full stop. On what basis then the report says the accused Manjunath with the intention to cause damage to the reputation of Devaraja created a false email? And on what basis do they say this? Huh? So look at the finding of the Central Science Laboratory. They also submitted that the report disclosed that the email ID ramulu.stumc@gmail.com is not found in the mobile phone of the petitioner marked as exhibit D1A and D2. And likewise, the document allegedly mailed through ramulu.stumc@gmail.com was not found in the mobile phone of the petitioner. Full stop. He therefore submits that there is no evidence on record to indicate that the laptop belonging to the petitioner was used, or the mobile phone belonging to the petitioner was used to forward the mail to the Medical Council of India, and therefore, no offense was made out. So, learned senior counsel further submitted that no useful purpose would be served in continuing the criminal prosecution of the petitioner. Learned HCGP on the other hand submitted that the investigating officer, after recording the statement of the witnesses, or particularly the statement of the complaint and radiologist English is correct. Computer what basis will you prosecute? Page 3. Correct, you are ಮಾಡಿದ್ದಾರೆ ಬಟ್ ಕರೆಕ್ಟ್ ಇವಾಗ ಇದ್ರಲ್ಲಿ ಇಲ್ವಲ್ಲ ಲ್ಯಾಪ್ಟಾಪ್ ಸೀಸ್ಟ್ ಲ್ಯಾಪ್ಟಾಪ್ ಅದ್ರಲ್ಲಿ ಏನು ಇಲ್ವಲ್ಲ how are you going to link learned counsel, the learned SCGP on the other hand submitted that the report of the Central Forensic Science Laboratory disclosed that the IP logs of ramolu.stumc@gmail.com was obtained from the Google, and physical address was obtained from respective service providers, and it was found that the physical address of the Gmail was traced to one Dr. Y.C. Manjunath at Kolar town, who is working as a radiologist at the Sri Chaudeshwari Hospital, Kolar. Stop. The investigating officer had visited Dr. Y.C. Manjunath on 24/1/2015, and his personal laptop was seized. Stop. He therefore submitted that there was evident material to establish the crime. Next para. I have considered submissions made by the learned counsel for the petitioner as well as the learned SCGP. Next para. The entire case revolved around the false email ID created. Full stop. The IP logs of the Gmail ID ramolu.stumc@gmail.com, which were obtained from Google, and Google, as well as the physical address obtained from the service providers, linked to the petitioner, and therefore, the laptop of the petitioner and the mobile phone were seized. Full stop. Though both these electronic devices were subject to examination, there was nothing found that this laptop was used to generate the email ID or to submit the complaint to the Medical Council of India. Therefore, there is no material on record to establish that the petitioner was the one responsible for creating the false email ID and in forwarding the complaint to the Medical Council of India. The prosecution failed to establish any motives on the part of the petitioner in sending the complaint against the complainant here, against the respondent number 2 herein to the Medical Council of India, and therefore, pursuing the investigation or pursuing the criminal case against the petitioner would only be a wastage of time and an empty formality. In that view of the matter, this petition is allowed. The criminal prosecution of the petitioner in CC number so on the file of so are quashed. The petitioner is set free. Yes. Jagdish, DC. The civil suit pending between the parties. Partition suit is pending. Yes, Mr.
That I don't have any plan.
Who has to complain? The Tahsil has to complain. Who are you to complain? No, who are you to complain? You mentioned that to the Tahsildar, let him decide to complain or not.
Otherwise, may not. Admittedly, may not give out about 4 times. By that person, that
Don't go into the merits.
yes, that's right. And person will
It's not necessary. Please tell us how you are interested. How are you affected?
My expectation is in the event if you got there or you don't take any action, you know.
What is the court done?
Taking cognizance of the matter.
What way? Please come to section 190. Here to stop. Yes, please read.
No court shall take cognizance. Any offences punishable under sections 173. Or of any abatement or attempt to commit any criminal conflicts except on the complaint in writing concerned or some other public servant who is the
Yes.
these offense members in the written complaint is coming.
ಆಯ್ತು ತಡ್ರಿ ಯಾರಿಗೆ ಮಧ್ಯದಲ್ಲಿ ಯಾಕೆ ಇದು ಈಗ ನಾವು ಟನ್ ಅಂತ ನೋಡಿತಿರಲ್ಲ ಮ್ಯೂಸಿಕ್ ಅಲ್ಲಿ ಟನ್ ಅಂತ ಒಂದು ಅದ್ಯಾಕೆ ಕುಡಿತೀರಾ ನೀವು? ಲೆಟ್ ಹಿಮ್ ಕಂಪ್ಲೀಟ್. ಎಸ್ ಮಿಸ್ಟರ್. No, 181.
The offences of being here or not unsafe.
181. What are reading?
All statement on work or recognition to the public servant or person authorized by minister. Who were being legally bound by and court to state it on any subject to any public servant or minister such work or leads to the public servant or other person as touching that subject, any statement is false. Which he either knows or believes to be false or does not believe to be true shall be punished with imprisonment of either for a term which may extend to 3 years, which shall also be liable.
What is the trial court? How can the trial court say?
Trial court may grant some.
Yes. How are your person agreed? Are you a person agreed? Yes. Let us see what are the facts.
or essential facts which are required to be created for the education of the are that we will complete and case CP's respondents releasing commercial expenses on the foundation that the company and the managing director recompense for establishing an endpoint the financial each person seeing that the plan machine order major on this the last upon the change of designing and drawing of complete plan to 15 minutes guarantee from the data. On basis of purchase order, the company senses of this also and has reached out. This person sees the company acknowledging the internal paid to each person as an advance, taking in view of commitment made by the company. As the company to further uncertain. In spite of substantial amount of money being paid by way of loss, most of the taken by as a consequence of influence of this person better back. So that they will get an extension from regarding the data. But the rules of the good systems one time to manipulate the connection that begins within the machines that are in this background. Sometimes it's logic being mentioned. On the basis an inquiry was conducted in this stated was not written to me. Whatever comments initially taken was satisfied by the court. Matter was limited to the fact that we agreed by the efforts of the order to finally,
this judgment has no bearing.
so far as section applicability of section 1, the
But this, first of all, this is a court proceeding, a civil proceeding, this was done. Where is the court proceeding here?
here cannot he gets to know plan.
Oh, sorry. No, what is your right? You please restrict your argument to that. What is your right to complain? What is your right?
This liberty may be reserved to me in about.
Let the Tahsildar file. We will not reserve any liberty to you. We will not reserve. You go, you do whatever you want.
So what happened?
No.
We will contend with what
The accused in CC number 134 of 2014 file of the civil judge and JMFC Sringeri has filed this petition challenging the cognizance taken by the court for the offences punishable under section 181 of IPC. Next para. The respondent number 2 herein filed a private complaint under section 200 of CRPC against the petitioner alleging the commission of an offence punishable under section 181 of IPC. It was claimed in the complaint that the respondent number 2 had declared before the Tahsildar that he did not own or possess any site within the limits of Sringeri, na? Within the limits of Sringeri town, based upon which the Tahsildar had taken steps for allotment of a site, for allotment of site, allotment of outside. Full stop. The respondent number 2 alleged that the petitioner alleged, the respondent number 2 alleged that the petitioner was in possession of more than one site, and therefore the affidavit filed before the Tahsildar was an apparent falsehood. Was false. Stop. The trial court, unmindful of the restrictions on exercise of power under section 195 1A, in respect of an offence punishable under section 181 of IPC, took cognizance of the offence based on the judgment of the apex court in the case of George Bhaktan versus Rabindra Leele and others. Criminal appeal, SLP criminal number 7531 of 2012. Being agreed by the same, the present petition is filed. Next, the learned counsel for the petitioner submitted that no court shall take that section 195 of CRPC mandates that no court shall take cognizance of an offence punishable under section 181 of IPC unless a complaint in writing is lodged by an officer writing by the public servant concerned or some other public servant to whom is administratively subordinate. Stop. He submits that section 195 1A does not carve out any exception for a private person to file a private complaint, and though he is not aggrieved, full stop. He therefore submitted that the cognizance taken by the trial court was only without jurisdiction and wholly without jurisdiction. Full stop. The learned counsel for the respondent number 2 on the other hand submitted that the apex court, while considering a similar set of facts in George Bhaktan versus Ravindra Leele and others referred supra, had held that there is no embargo on the power of the court to take cognizance of the offence on the basis of the complaint filed by a private complainant. Stop. He therefore submitted that the trial court was justified in taking cognizance. In order to have considered the submissions made by the learned counsel for the petitioner as well as the learned counsel for the respondent number 2. In order to understand the contours of section 195 of CRPC, particularly in reference to taking cognizance of an offence punishable under section 181 of ITC, section 195 1A is extracted below. Stop. A fair perusal of section 195 1A leaves no doubt that the person aggrieved is only the person aggrieved respect of an offence punishable under section 172 to 188 is only a public servant concerned or a person who is administratively subordinate to him and none else. Full stop. In the case on hand, the respondent number 2 was not a public servant nor a person aggrieved by the allegedly false affidavit filed, the alleged false affidavit filed by the petitioner herein. Full stop. No offence was made out against the respondent number 2. Full stop. The respondent number 2 was not an aggrieved person who could complain against the commission of the offence punishable under section 181 of the Indian Penal Code. In that way of the matter, the Full stop. The reliance placed by the trial court on the judgment of the apex court in the case of George Bhaktan referred Supra is wholly misplaced, as the facts were entirely different in that case. Full stop. In that way of the matter, comma, the petition is allowed. The impugned order dated 26/9/2017 passed by the trial court is set aside. Very respond. Very respond. No liberty, Mr. You go, you do whatever you want. I have not said a word about on the merits of the case.
Because government authority.
Right, so what you have to do is you have to go and tell that the law is this, you do this and that. Let us. You have one more round of litigation before the High Court in a writ petition for a direction to consider the representation.
Not coming the way.
No, that is not emboldened. Next. Give it to Oglebody. This term? 56. Tomorrow. 2017 petition. Will you go back home empty-handed today? Dada, you go back home empty-handed. Cognizance is taken only for 427. Can happen only in Bangalore. These kind of offences can only be reported in Bangalore.
I was not what is the Indian They are the experience. Literature is over, hopeless. Development takes over place. It develops flat.
They will enter into understanding. The water, during rainy season, not that goes on the floor of the water. This entire arrangement of the face is not. That excellent. Now whether, so what 27 also goes to minor offense, then the act is 50 rupees. Last, house area. Tomorrow I am. By good followership of one company.
Correct, Mister, if you level the land at a higher spot, the water is bound to flow into his land, huh? You purchase it, but ensure that the water from your land does not go into his land.
The act of God.
Mister, this is not an act of God, this is an act made by you. Act of God ಅಂದ್ರೆ God ಚೆನ್ನಾಗೇ ಮಾಡ್ತಾನೆ, ನಾವು ಮಾಡೋದಷ್ಟೇ. So the nature will take care, Mister. Water will find its level. The water will find its level, its flow. It will flow from the higher altitude to the lower altitude. So if you cut that and if you level the land, where should the water go? You go to the next level, which is the land of the complainant. And obviously it will damage the crops. Or you enclose it by a compound wall, ensure that not a drop. So not a drop of water should go from your land to his land. Not is. Anyway, you have to put up a compound. You will put up a compound. To ensure that water does not seep into his land. Otherwise, the design of an agricultural land is water will flow in a particular corner. Some corner, they will divert the water to a corner. Now, in every part of the land, from your land, which is at a higher range, it will flow into the land of the complainant, along with the mud, soil, adu idu ella. Yes, learn counsel for the respond number 2 each time. When do you want to argue? Not tomorrow. Go to the list on 6th March. CP Putraja, how do they respond? First petitioner's father? First petitioner, first petitioner is the mother of? Read the relevant portion, don't read the entire.
Last page number 15 last 2017 is after 12 2017 ಇವೆರಡು ಒಂದು ಕಡೆ ನನಗೆ ವಕೀಲರ ಮೂಲಕ ನೋಟಿಸ್ ಆಗ ನಮ್ಮ ಮನೆಯವರು ನಾನು
What is the allegation? Use the lane. Charge sheet.
ಇವಾಗ ಸುಮಾರು 3 ವರ್ಷದಿಂದ ನಾಗರಾಜ ಮದುವೆ ಮನೆಯಲ್ಲಿ ಉಪಯೋಗ ನಾಲ್ಕು ಈ ಮದುವೆ ಆಗುತ್ತೆ ಅದನ್ನು ಎದುರಿಸಿ ಕೇಳಿದ್ರೆ ಏನು ಮಾಡಿ ಹೇಳ್ತಾರೆ ಈ ಮೇಲಿನ ವಿಚಾರ ಏಟು ಮೇಲಿನ ವಿಚಾರ ಏಟು ಆರೋಪಿ ಸುಖಾಂತರಕ ಏಟಿಗೆ ಆರೋಪಿ ಸಹ ತಿಳಿದಿರ್ತದೆ ನಂತರ ನಾನು ಒಂದು ದಿನ ಈ ಮನೆಯಲ್ಲಿ ಬೇರೆಲ್ಲ ಹುಡುಗಿಯನ್ನು ಆಗುತ್ತೆ ಇದು ನಾವು ತೋರಿಸುವ ಹುಡುಗಿಯನ್ನು ಮದುವೆ ತಾಯಿ ಹೇಳುತ್ತಿದ್ದಾರೆ ಬೇರೆ
ಏನು 498 ಗೆ ಏನಿದೆ ಇವ್ರ ಮೇಲೆ 506 ನಲ್ಲಿ ಏನಿದೆ ಏನಿದೆ 417 ಆಗಲಿ ಏನಿದೆ If anybody said that ಈ ತರ ಬೈದ್ಲು ಈ ತರ ಮಾಡಿದ್ಲು ಈ ತರ ಹೊಡೆದ್ರು ಯಾರು ಹೇಳಿದಾರ ಯಾರು ಹೇಳಿದ್ರು ಯಾರಾದ್ರೂ ಒಬ್ರು ಹೇಳಿದಾರೆ ಹೇಳಿ ಯಾರಾದ್ರೂ ಒಬ್ರು ಏನೋ ಹೇಳಿದಾರೆ ಹೇಳಿ against this ಸೇಮ್ ಅವ್ರು ಕಾಪಿ ಕೊಡ್ಬೇಕಲ್ವಾ ಸೇಮ್ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಗೊತ್ತಿರುತ್ತೆ ಈಸ್ ನಾಟ್ ದಿ ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್ ಕಾಪಿ ಕೊಟ್ರೆ ಓದ್ ಹೇಳ್ತಾರೆ ಹಾ see if you correct Mr. if you want to rope in the relatives you should say specifically urine ಮಾಡಿದ್ರು ಅವ್ರೇನ್ ಬೈದ್ರು ಇವ್ರೇನ್ ಬೈದ್ರು without that you can't simply make a general statement and rope in all the relatives ಅಷ್ಟೇನಾ ಏನಂತ ಕೊಲೆ ಬೆದರಿಕೆ can that be proved ultimately prove ಮಾಡಕ್ಕಾಗುತ್ತೆ ಸೆಟಲ್ಮೆಂಟ್ ಆಯ್ತು ಮದ್ವೆ ಆಗಿದೆ ಎಲ್ಲ ಆಗಿದೆ ಇವಾಗ ಮದ್ವೆ ಆಗಿದೆ ಕರ್ಸಿ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿಸಿ ನಿಮ್ ಬ್ರದರ್ ನಿಮ್ ಮಗನೇ ತಾನೆ ಕರ್ಸಿ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿಸಿ ಗಂಡ ಹೆಂಡತಿ ಒಂದು ಮಾಡಿ ಯಾವಾಗ ಅವ್ನು ಇವ್ರು ಎಲ್ಲಿದ್ದ ಕರ್ಸ್ತೀನಿ ನೀವೇ ಇಲ್ಲಿಗೆ ಕರ್ಸಿ ಸರ್ ಇಲ್ಲಿಗೆ ಕರ್ಸಿ ಯಾವತ್ತು 3 weeks ಎಲ್ಲ ಅದೆಲ್ಲ ಕನ್ಸೋದಲ್ಲ ಒಂದು ವಾರ ಇವಾಗೆಲ್ಲ ಜಡ್ಜ್ಗಳು ಜಾಸ್ತಿ ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ಕಷ್ಟ ವಾರ 2 learned counsel for the petitioner and the learned counsel for the respondent number 2 submits that learned counsel for the respondent number 2 prays indulgence of this court to ensure rapprochement between the respondent number 2 and her husband So learned counsel for the petitioner submits that will ensure that the accused number one appears before the court. Accused number one appears before the court on 14th. This is on 14th March 2020. Tomorrow granted this extent to the next date. ಇಲ್ಲ ಮದುವೆ ಇಲ್ಲ ಡಿವೋರ್ಸ್ಗೆ ಎಷ್ಟು ಕೊಡ್ತೀರಾ ಎರಡೂ ಹೇಳ್ಕೊಬೋದು ಇಲ್ಲ ಮದುವೆ ಜೊತೆಲಿ ಗಂಡ ಹೆಂಡತಿ ಜೊತೆಲಿ ಇರೋದಕ್ಕೆ ಮತ್ತೆ ಬಿಟ್ಟು ಹೋಗೋದಕ್ಕೆ ಎಷ್ಟು ವೆಂಕಟೇಶ್ ಹರಬಟ್ಟಿ ವೆಂಕಟೇಶ್ ವಾಟ್ ಇಸ್ ಚಾಲೆಂಜ್ There's no representation for the respondent. And the last chance list on. So MV Banu Prakash. ಒಂಬತ್ತಿಲ್ಲ ಅಲ್ಲ 9-10 ಇಲ್ಲ 9-10 ಹಾಕಲ್ಲ ಈ ಮ್ಯಾಟರ್ಸ್ ಇದು ಸಿವಿಲ್ ಮ್ಯಾಟರ್ಸ್ 9-10 482 only on Wednesday, so Monday, Tuesday, Wednesday. 13. Banu Prakash. Level number 66/4 of Yavanakere. What is the extent? 22 Volta. Why was it acquired? The formation of what? Formation of road. Yes, so what basis? There can't be any basis. Yeah, basis irbeku. No basis andre. There should be some basis. Where is the order passed to the land? Reference court ಇಲ್ಲಿ. Please read the order passed to the reference court. In sales statistics method count is there crop capitalization. What is the method adopted? Number 66 is a dry land. There is putting a tank. Admittedly, P1 did not produce a village map to establish that survey number 66 is aborting a tank. Nor did he file objections. There is absolutely no acceptable evidence with regard to P1 or the profit of. What? Sale deed date another. What is the sale deed date? 1997, huh? In rate list in exhibit P4, what was grown in the land? RTC lane ಅಂತ ಇದೆ ಕೊಡ್ರಿ ಇಲ್ವಾ? ಇಲ್ಲಿ ಸೇರಿಲ್ಲ. RTC lane ಅಂತ ಇದೆ. What is grown in the land? ಕೊಡಿ ಸರ್ ಇಲ್ಲಿ ನೋಡ್ಕೊತೀನಿ ಕೊಡಿ. ಎಲ್ಲಿದೆ exhibit P2 to P8 ಎಲ್ಲಿದೆ? No crop details, Mr. We'll give him an opportunity. Let him produce further evidence. ಮಾಡ್ಲಿ. ಜಾಸ್ತಿ ಕೇಸ್ ಬಂದಿತ್ತ ನಿಮ್ಗೆ? Too many cases were listed today. ಏನ್ ಸರ್ ಈ ಸಣ್ಣ ಪುಟ್ಟ ಕೇಸ್ ರೆಡಿ ಆಗಿದ್ರಿ ಹಿಂಗೆ ಸರ್? The petition, the appellant has filed this second appeal under section 54 bracket small Roman 2 of the Land Acquisition Act 1894, challenging the judgment passed by the appellate court in MA 57 of 2011, as well as the order after the award of the reference court. This is the judgment of the appellate reference court dated 9/8/2010 in LAC number 28 part 1980. Next paragraph. The petitioner claims to be the owner. The petitioner is the owner of serial number 66/4 of Yavanakere village. Which taluk? Yavanakere. Shumaga taluk. Yavanakere, Shumaga taluk, measuring 22 hectares of land, which was acquired by the respondent in terms of a preliminary notification dated 29/4/1997 for the purpose of formation of a road. Stop. The possession of the land in question was taken on 1/1/1984. ಮುಂಚೆ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ರ 1/1/1984. And thereafter the award was passed on 29/6/1998, determining the compensation at the rate of rupees 12,208 per acre. Stop. The petitioner, the appellant sought enhancement of the compensation by a reference under section 18 of the Land Acquisition Act. Stop. It was contended by the appellant that the market value of the land in question measured more than 1.5 lakhs per acre. So we also contended that the land acquired was though classified as dry in the revenue records, but yet lay adjacent to a tank and was irrigated. Stop. We further claimed that by formation of the road in in the land belonging to him, survey number 66/4 was divided into two parts, which had no intrinsic value. Stop. He therefore submitted that. He therefore claimed enhanced compensation. Stop. The reference was opposed by the beneficiary, who claimed that the land acquisition officer had valued the land acquired based on the sales statistics method. Stop. He submitted that the sale deed of the year 1997 indicated the value of the property in Javanakere was 12,280 per acre. Therefore, the appellant was not entitled to enhanced compensation. So, based on these rival contentions, the reference was set out for trial. The appellant was examined as PW1 and we marked exhibits P1 to P9. So the beneficiary did not lead any evidence and did not mark any documents. Stop. Based on the oral and documentary evidence, the reference court held that the land in question was classified as dry in the revenue records and there was no evidence produced by the appellant to establish that it lay adjacent to a tank. Full stop. It also held that the appellant did not produce any documents to establish the market value of the property acquired as more than rupees 12,208 per acre. Full stop. It also what is exhibit P4? Then none. Pushki. 45,000. Per acre. Stop. It relied upon the notification issued by the state government under section 45 of the Karnataka Stamp Act. And held that the guidance value in respect of Javanakere, guidance value in respect of dry lands in Javanakere was fixed at rupees 45,000 per acre. Therefore, the land of the appellant, which measured 22 guntas, commanded a market price of only 12,208 per acre. It consequently rejected the reference and upheld the award passed by the land acquisition officer. Being agreed with the same, the appellant filed miscellaneous appeal 57/2011 under section 54(1) of the Land Acquisition Act 1894. The appellate court two by a cursory order, upheld the order passed by the reference. Being agreed with the same, the present appeal is filed by the appellant. The land counsel for the appellant submitted that the land in question was submitted, the possession of the land in question was taken over in the year 1984, while the preliminary notification was issued in the year 1997, and the award was passed in the year 1998. Full stop. He submitted that in view of the fact that a large portion of the land in question was used up for formation of the road, the appellant could not make use of the remaining part for the purpose of agriculture, and therefore there is no mention of any crop being cultivated in the revenue records at Exhibit P2 and P8. Full stop. Further, he contended that Exhibit P4 only set out the guidance value of dry land in Yavanakere village at a sum of rupees 45,000 per acre. He submitted that guidance value does not represent the actual market value, and no effort was made by the land acquisition officer or the reference board to ascertain the actual market value. Full stop. He therefore submitted that the appellant may be given. He further submitted that the land in question lay adjacent to a tank, which was not considered by the land acquisition officer. Full stop. He therefore prayed that that he be granted an opportunity to lead further evidence before the reference court to establish that the market value of the property acquired is more than a sum of rupees 2,208 per acre. Full stop. The land council contended that since the appellant was dispossessed from the land in question in the year 1984 and was deprived of any compensation from the year 1984 till the year 1987, the land acquisition, the reference court may be directed to consider this at the time, before deciding the market value of the land acquired. The land council for the response is absent, and therefore this court did not have the benefit of the arguments of the land council for the response. To be that as it may, it is not in dispute that the land in question lies within Shumaga Taluk, and is therefore very close to the district headquarters. Full stop. The land in question was the possession of the land in question was admittedly taken on 1/1/1984, while a preliminary notification to acquire the said land for the purpose of formation of the road was issued on 29/4/1997. To stop this, therefore, indicated that for nearly 13 years, the appellant was deprived of the benefit of the said land. To stop. The award was passed on 29/6/1998, determining the compensation at a sum of 12,208 per acre, based on a sale deed. Based on a sale deed. Only the sale deed. Based on the this is based on the certified copies of the sale deeds. Based on please. What basis 14,000 ರೂಪಾಯಿ ಹೆಂಗಾಗುತ್ತೆ? On what basis? ಇದನ್ನ ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ. On what basis the court is arrived? Per acre based on a sale deed. Sale deed, where the sale consideration was mentioned as rupees 14,000 in respect of survey number 14 of Yavanakere, measuring 1 acre 6 quintas. Full stop. It also considered Exhibit P4, which was the notification issued by the state government determining the guidance value for the purpose of stamp duty and registration, and held that the guidance value of land in Devankere in the year 2009 was fixed at a sum of 45,000 per acre. And therefore, determined the market value at a sum of 12,208 per acre. Full stop. As rightly contended by the Land Council for the appellant, when the land in question was not used for agriculture from the year 1984, obviously there could be no increase in the revenue records reflecting the crops grown in the land in question. Full stop. The trial court, the reference court, the land acquisition officer, the reference court as well as the appellate court have failed to consider the potency of the land in question for the formation of for non-agricultural residential use, since on either side of the road, either side of the road could be used for the purpose of non-agricultural, could be used for non-agricultural use. Full stop. The land acquisition officer as well as the reference court also failed to consider that the land in question lay adjacent to a lake and therefore, could be used for agricultural purposes. Full stop. The reference court ought to have taken adequate steps to secure information about the situation of the land as well as the potency of the land for non-agricultural use, or the crops that could be grown in the surrounding vicinity to determine the market value of the land in question. The refusal of the reference court to determine the land acquisition based on determine the value of the market value of the land in question based on these factors is unjustified, is not justified, In that view of the matter, the impugned order passed by the reference court as well as the judgment of the appellate court warrants interference. Hence, the appeal is allowed. The order dated so passed by so in LAC number 28 of 1998, as well as the judgment dated so passed by in appeal of miscellaneous appeal number 57 of 2011 are set aside. The case is remitted back to the reference court, which will provide an opportunity to the appellant to read further evidence. To stop. The appellate court shall take into consideration the fact that the appellant was deprived of the land in question from the year 1984 and determine the compensation based on the above. To stop. The appellant shall appear before the reference court on 31st March 2023 and file all additional documentary evidence and read further evidence if required. And the reference court is requested to dispose of the reference in a period of 3 months thereafter. Tomorrow.
There is a specific direction. Petition is,
24. Yeah, 25 is I think.
Special direction was given. Considering again on.
Yes.
It's like. It was the same, in similar order. Instead of earlier, actually. Speaking to the people.
Professor, this is.
One.
There's no representation for the response. Yavatman,
Yes, for the first respondent, my lord.
are you ready?
Yes, my lord, ready, but this will take some time.
Ah,
Their contention is. Sorry, my lord.
I hope you are not scaring me.
Their only contention is, my lord, that in the earlier direction of this court is not followed anta.
Where's the earlier
Cannot-
direction? Where's the earlier direction? In MF, in MSA?
50 of 2011.
Yeah. Kudi, idhra kudi. Of 2011. Yeah, let's go to the page of the in terms of rule 24 of order 21. Yes. What happened thereafter? ಯಾವ ಮಾಡ್ತೀರಿ these matters will take more time. Ninth, huh? It's from 9th. Due to want of time, some of the appeal could not be taken up. It's on 9th March.
Very grateful, my lord.
Yes, yes, please take. Surupan. Yes, Abhijit for R4. Suraj for R3. Officer directed to delete the name of yes, Abhijit from the cause list. Yes, what is this? Earlier in Gairadido. Suraj, yes, Suraj.
Some traditional. By the name of Zen Technology. So that the company undergoes some dispute. The tradition of Bangladesh in India. The majority shareholding in the particular company was held by the son. Was on 15/7/2018. We come to my
So
office.
this company is registered where? In Dubai.
In Dubai. That is like it's their own, that is the abbreviation of a private entity. So what may really come from this, on 15/7/2018, the third installment, some other. Come to my Dismissal. From 15/7/2018. I lodged a complaint. My complaint is issued as an NPR. So you kindly
Social is not there. Why waste your energy? to respond, due to want of time, the petition could not be taken as discount. Tomorrow we'll send to the next petition. Nothing else.